call this meeting to order. And this is notice of hearing on determination of violation of subcontractor listing law and intention to assess a penalty. I'm Darrell Hawkins, I'm chairman. And let me introduce Kent Glenzer, who is right there. Oh, there we are, okay. And also Stephen Milich. Thank you, Stephen. And we are the three members of the appeals board. I want to say, as we start, we've run into this minor glitch, which we will talk about today, but City of Monterey really appreciates the work that the contractor has done. And I've lived here 65 years in Monterey and watched the whole progress from, my parents wouldn't even let me go growing up to that area of downtown. It wasn't a good area. And the urban renewal came on. It sat as a vacant lot. It was going to be J.C. Penney's for a while. That failed. And then we got the idea, let's make a conference center. So we are glad for the conference center, but especially glad for a SOM designed, one of my favorite architects, and for the contractor to successfully complete it. We're proud of it. We wish we could use it, but that will come. And so we appreciate the City of Monterey having this and for the work that the contractors have done. Alicia,
Yes,
anyone checked in for any public comments?
No, not at this time, sir.
Okay. Okay, I've already introduced the amount, the topic and subject.
I'm sorry, pardon my interruption. Alicia, it does look as though Paul Bruno is raising his hand to make a comment under public comments for items that are not on the agenda.
Okay. I do see that. Sorry about that. Mr. Bruno, if you'd like to make a comment for public comments, please feel free to do that now.
Actually, I'm sorry. I didn't realize that it was only for items not on the agenda. I do want to make a comment on the item that's on the agenda. I guess that'll be later. Sorry.
Yes, that's correct. Thank you so much.
Okay, we will, a couple of guidelines here. This is an informal hearing. Informal rules of evidence do not apply. The board may consider any evidence or information deemed relevant and reasonably reliable, and the parties will not have the right to cross-examine the witnesses. Each side will have a total of 45 minutes to initially present its case, and the last 5 of those will be reserved for the board to ask any follow-up questions. And the board members will hold their questions until that time. And then each side will have 10 minutes for reply and closing arguments. We will start with Stronghold Engineering has a burden of proof, so they will present first. But first, to the other board members, we need to disclose any ex parte contacts. And if you've received any information relevant to this appeal from other staff or other people, that's legal, but we just need to note that that has taken place. So has anyone discussed this or had any contact regarding this separate from what we're hearing here today and the notes that we have received? And I have not. Stephen, any thoughts on that?
I've spoken to nobody, received no communications other than the package of what I received.
Okay, and Kent, have you had any outside?
Nothing outside, no.
Yeah, okay.
No outside communications of any sort.
Okay. My only contact has been riding my bicycle through the courtyard there, and I love it. It's a beautiful place. Okay, city attorney statement.
I'm sorry, this is Denny. Do we speak up if we've had any outside communications? Because I've got a communication from one of the board members, I guess, an email from them. I don't know if it's a board member from Paul Bruno. I did receive an email on this.
Oh, no, Mr. Bruno is not a board member, so
Okay.
you don't
Okay.
need to discuss that.
Okay.
Thank you. This was just the board members.
Okay.
I wanted to make a brief statement. I'm the Assistant City Attorney, Karen Salama, and I will be advising the board today. I've been screened off from other members of the City Attorney's office and have had no contact with the Public Works Director or other members of my office regarding this matter or their preparation for this matter. I just wanted to state that for the record, and the Chair, you may continue.
Okay, good. Well, thank you. That's our beginning. And so we will proceed now with the contractor's presentation as you provide your case towards this issue.
Good afternoon. This is Andrew Van Ornum, and I represent Stronghold Engineering Incorporated. Nice to meet you all, board members and other staff people. I have a couple questions. One, I thought that the statement was that there would be no cross-examination, but I believe that that's something to the contrary was stated in the letter from Mr. Witry. Can I get clarification on what the board's interpretation of cross-examination, the right to cross-examination is?
Let me check Mr. Witry's letter that went to you. Mr. Witry obviously is not a board member, but if you were told that you would have that opportunity, we can allow that. Why don't you go ahead with your presentation at this point?
Let me just point to the notice of hearing, which was attached to Mr. Witry's letter. It says in the bottom paragraph, you will be able to call and cross-examine witnesses. So let me just point you to that, number one. And I'd
Okay,
also,
that's fine. We can do cross-examination.
okay, I'd like to ask another kind of foundational question, Ms. Salama. You're part of the city attorney's office, is that right?
Yes, as I stated, I am the assistant city attorney.
Okay, and the city attorney is Ms. Davy, who's also on this call, correct?
That would be me,
Correct.
yes, Davi.
Davi, I apologize. Now, Ms. Davi is also listed as counsel of record in the litigation between Stronghold and the city. Is that correct? You agree?
Yes, so we have a due process screening implemented in our office, and Assistant City Attorney Karen Salama has not had anything to do with this matter before the board today.
Would you?
And I'm not representing the city in this matter before the board today either. Mr. Firstman is.
Mr. Firstman's representing the city before this board today?
Correct. Correct.
And your role is just as an observer?
Correct.
Okay. Mr. Firstman, I'll ask you this and have your office confirm this, but I know that during our disputes over claims of privilege in the litigation between the city and my client, Stronghold Engineering, that there are a number of entries where Ms. Salama is asserted to be a participant in privileged attorney-client communications between the city and its attorneys involving this dispute. So I would ask that you acknowledge that that has been a claim and that it remains a claim that Ms. Salama has engaged in privileged communications just directly related to the litigation between the city and Stronghold. Would you agree to that?
Well, first of all, I can't say that of personal knowledge. I know the lawyer that's handling that dispute with your office. The members of the city attorney's office are on the pleadings in the litigation between our clients. And I think that speaks for itself.
Okay, so you would agree that one city attorney is providing legal advice to the hearings board here in this case, and another city attorney is in an adversarial position with respect to Stronghold in the underlying civil litigation in Santa Clara Superior Court.
Well, first of
Is that
all,
right?
I'm not going to be cross-examined by you. And second of all, the pleadings speak for themselves. If you have evidence to put on, please put it on.
Okay, we will. I will need a break to pull up the privilege disputes, of which there were many, in which Ms. Salama is identified as a participant in privileged communications. So I want to note that for the record. If you won't agree that that's a fact, then I will get some documentation for it. I would also like to ask an initial question related to why it is that Stronghold has the burden here, because it is the city that is giving an intent to potentially assess penalties. And I raised in our briefing to the appeals board that the city bears the burden of assessing penalties and proving that penalties are warranted in this case. I haven't heard an argument or authority as to why that is incorrect, but I'm hoping that the city will illuminate me, because Mr. Witry has not assessed penalties. Penalties have not been assessed, and that is a burden. And the city also has the burden to do that in a timely fashion, and that has not been done. So the other introductory remark I'd like to make is to ask and confirm that everybody at the board has received the briefing and the affidavit and accompanying exhibits that we circulated to the city attorney last night pursuant to the notice. Has everybody seen that?
Yes, I have.
Yes.
Yep,
Okay, thank you.
you're welcome.
So did you want an answer on the burden of proof, Mr. Van Ornum?
Yeah, I see nothing in the letter from Mr. Witry, either one, that indicates why or the authority for a burden being placed on a defendant who is potentially being assessed penalties.
Well, I think your own brief or letter that you wrote acknowledges the Coast Pump Associates decision at page 427. Now, I understand that you say it is distinguishable and you don't see anything in Coast Pump Associates that says that your client has the burden of proof, but it's right there.
Okay, so it's your position then that in a situation where a city wants to levy a penalty for some claimed violation of contract or statute, that it doesn't have to put on evidence of a violation and prove that before a essential taking of the money and property of the defendant occurs? In other words, you're saying that Stronghold has the burden to disprove a claim before it's even made.
I don't understand what you just said. Mr. Witry made his findings. They were deferred to this board because of his involvement in the dispute. His letter is extensive and the exhibits, they run into the hundreds and hundreds of pages. Now, if you don't see that, of course, it's your job to say that. It's your job to say that you see no evidence. But I believe the letter and the exhibits really do speak for themselves.
Well,
And
let me read to you.
Witry's findings speak for themselves.
Let me read to you from the letter. Because of the gravity of the potential violations, that's his word, not mine, and the personal involvement of the city administrators in the SEI contract, the city manager has referred the hearing of this matter to the appeals hearing board. That's it. There's no finding, there's no conclusion that there is a penalty assessed. There is simply no finding. So I would disagree that the burden is on Stronghold at this point. The burden to produce evidence and establish a violation that justifies a penalty is on the city. In other words, any other outcome is a violation of our due process rights, procedural and substantive.
I believe what he says is the case law provides that a city administrator, or to hear the matter, I've made the preliminary determinations above. He defers to this board as the final decision maker. They've asked you to go forward with your evidence. You presented it last night. You've had hours for months. I'm waiting.
I reiterate that this is a violation of due process and it is an unfair process. All right, that being said, the evidence in the affidavits, I think, stand on their own. There simply isn't a basis to conclude that there was a violation of the listing law that occurred within 1 year of the notice of or this hearing. I'm going to make this more of an opening argument because I think the evidence stands on its own. There were official emails acknowledging and accepting the substitution of scopes of work to both European Designs Paving back in 2017 and to West Coast Concrete, Perry DBA, West Coast Concrete. West Coast Concrete was a listed sub. Stronghold complied with the purposes and the letter of the listing law in writing them down on the bid list. They made an error with the license number and they didn't technically list out the entire legal name. Mr. Witry, and I haven't seen any evidence from the city that indicates, or in the case law that indicates that you have to write down the exact legal name of an entity on the bid list. So West Coast was known. FD Thomas was also known as a participant on this project, and no action was brought within 1 year of when those people were known or participated in the project. Quite simply, this to me is an obvious extension of the city's litigation tactics against Stronghold in the civil litigation, and is done for harassment purposes, as Mr. Witry's own office has approved the substitutions and the participations of all of the subcontractors that are at issue in this case. I don't know what else I can say beyond what is said in the affidavit Mr. McGahee testified to in the documents that verify all of those things. So I believe that we have responded to the suggestions made by the city, and the fact that we would have to go forward and disprove claims against us before they've actually been established, I think is unfair. So I think at this point, I suggest that perhaps the board members should ask questions of either the witness or me, and I'd be happy to point to evidence and clarify the various issues that are in the papers.
I just a procedural point, or maybe it's just a stipulation. Are we in agreement? Because it will save a lot of time, that the letter from Mr. Witry and exhibits, and your letter and the affidavit of Mr. McGahee and exhibits are admitted into this record? Is that the approach that you want to take? Because the affidavit of Mr. McGahee is hearsay, but it'll save us a lot of time.
Well, then I'll object to everything that's hearsay as well, from Mr. Witry and so forth. Mr. McGahee stated under penalty of perjury in a properly authenticated affidavit with exhibits that was submitted pursuant to the notice of this hearing and the agenda. Therefore, at my understanding, according to the city's own rules for this proceeding, that the evidence from Stronghold has been received and has been acknowledged. I don't see what the objection to it is, because it's in the same format that was requested.
No, I don't want to object to it. I want to know if we are in agreement that both submissions are submitted, so we don't have to go through all of them. I'm fine with that. I just want to know if that is your position, if we can go forward on that basis.
You want to stipulate they come into evidence.
Yeah, that'll save a lot of time.
I will stipulate that they'll be received. I'm not conceding anything as to the substantive meaning of any of
Okay.
it.
Same, that's fine. Okay. So is Stronghold resting? Is that?
I mean, I'm going to reserve all my time till I hear the case against us that's if it's not contained within the documents that have been submitted by the city.
Okay, if you're reserving your time, Chair, should we move on to the city?
This is above and beyond me. If that's what you want, yes. If that's the appropriate direction.
Well, Stronghold, I believe, has indicated that they're resting their case. Is that correct?
No, that is not correct. I'm going to reserve my time for rebuttal to what I hear from the city. I strongly disagree that we have a burden to go forward to disprove claims that haven't been established or a finding hasn't been made.
Well,
So
I don't think the board is asking anyone to disprove anything, but we're asking to see compliance with the listing law. And that was what I think the board would find helpful if you addressed Stronghold's compliance and prove the compliance with that.
Again, I respectfully disagree that that's the burden that is to occur in this case. I believe that we have established our performance and the approval of the actions with regards to all of the subcontractors that took place on this case in this project. And I believe as to all of the penalty claims that have been asserted in Mr. Wittry's letters of September 14th and October 23rd, all of those purported violations are untimely and late and cannot be considered at this point.
Would it help expedite matters if we knew what document or documents you're referring to that say that the statute of 1 year was exceeded?
Yes, I will point you to council's Mr. Firstman's own memo that indicates that statute of limitations for penalties in a very recent case, and I don't have the reference right in front of me, but also Code of Civil Procedure 430 or 340 established that a statute of limitations for an action for penalties is subject to a 1 year. It's a 1 year statute. All of the actions, pardon?
Maybe when it comes time for argument or council can address that, because that seems to be an alleged affirmative defense, correct?
It is, and I think the timing of the purported violations are all indicated in Mr. Wittry's letter. As Mr. McGahee in his affidavit established that there were affirmative approvals by the city.
Yeah, I understand that. Maybe that can be addressed in closing arguments by both sides, rather than take up the time arguing it now. Now is the time for the presentation of evidence, as I understand it. Just wondering.
Okay. Well, the evidence is as we submitted in our affidavit and the documents and exhibits that are attached to it. So Mr. McGahee here is here to answer any further questions from the board or answer questions from the city related to his testimony in the affidavit.
Okay, since it sounds like you're not introducing any further evidence at this point in time, Chair Hawkins, it makes sense if you agree to have the city present its evidence.
And I have a question. I received something at 10 o'clock this morning. Is that what Mr. Oram is referring to? Because I had other doctor's appointments and other thing, and I don't know if I've read the whole thing or not yet.
Just to clarify for the record, in response to the notices, the agenda and so forth, I forwarded yesterday evening to the email address indicated a letter dated November 17th, 2020, which lays out in 13 pages chronology and arguments as to Stronghold's position. And supporting that was an affidavit from Mr. McGahee, which is, I don't know, a number of pages long, and it contains exhibits A through R, which were attached, that lays out the chronology of the listing law issues and the various communications indicating review and approval of the actions that John Holt took, and giving background as to the project.
We've delayed this hearing for a month, and to receive that 10 o'clock on the day of the agenda, I don't think is appropriate. I leave that question, I don't know, but I leave that to our Monterey attorneys.
Well, it's
We-
fine that
we
they can
responded-
submit it
yeah.
whenever they want. I mean, I think board member Hawkins is making it clear that at this point, he has not had a chance to fully review that. Is that correct?
Well, I've read several pages, but I was confused as what the document consisted of. Were there more pages in the first 3 or 4 pages that I read?
Yes.
Okay. Well,
Yeah.
I think that's not very timely information, the day of the hearing.
And in light of the fact that Mr. Wittry's letter, I believe, said that it would request all documents be filed by the SEI by the end of September. And, or excuse me, the end of October. Yeah, the end of October. And they arrived, what, yesterday, which November 16th? That's hardly timely.
Where is that notice? Because that was not provided to us.
That is in the notice of hearing. On the bottom of the notice of hearing that was sent to you by October 30th, 2020, please identify the names, addresses, and emails, by emailing, et cetera, et cetera. Please email any supporting documents prior to the meeting so we can provide to the board members and to the staff. Proceedings are recorded. You know, how many pages did you of documents to review did you send the day before the meeting, or 2 days, Sunday before the meeting, or Monday? I mean, it's just like dumping a whole bunch of stuff. I'm sure you can understand our concern.
Yeah, we responded to the notices that were provided to us. If you would like, I would be happy to walk you through the affidavit. The documents are organized by subcontractor and bid. There are a number of issues that are addressed here. Essentially, there's 4 allegations of listing violations. So Part A covers the issue of Perry Coast DBA West Coast construction. That is a purported listing violation. There is a second purported listing violation, which is the substitution of European paving designs for Rinaldi for pavers work scope. There is a claimed violation for substitution of West Coast, who is the same as Perry DBA West Coast Construction, for the stone veneer scope of work. And then there is a presumed issue with FD Thomas Inc. for waterproofing related, again, to these pavers and veneer scopes of work. The affidavit addresses each of those, and let me just summarize the allegations that there was a listing law violation related to West Coast, and the fact that, as I understand it, the argument is that a license number for a different entity was included on the original bid list, and that second, the name was written down as West Coast Concrete instead of the full legal name of West Coast Construction, which was Danny Perry DBA West Coast Construction. On that first point, in starting at paragraph 5 on the second page of the affidavit, Mr. McGahee made clear or pointed out that throughout the course of the contract, that the shorthand name for West Coast was often referred to as West Coast Concrete, and that they were doing part of the concrete and other trade-related work. Mr. McGahee pointed out that this same entity, West Coast, submitted a bid. That same entity was the entity that SEI subcontracted with. It's the same entity that SEI used throughout the project for concrete-related work and other scopes. In other words, there was no substitution. It was the same legal entity the whole time, and there was only either a shorthanded reference to West Coast Concrete, which, by the way, is what their web domain shows up as on their letterhead in various documents that are part of the project record, and with which the city negotiated, reviewed, and used in their own exhibits. In fact, I think exhibits that they rely on in Mr. Witchery's letter refer back to West Coast Concrete letterhead, which indicates who West Coast Concrete is. The name of the estimator is on it. West Coast was always a subcontractor that was intended to be used by Stronghold. There's no substitution, period. If anything, it was just a misreference. So accordingly, there can't be a violation of the listing law if there's no substitution. Second, with regards to the substitution of work from Rinaldi for pavers, that is addressed in starting in on part D, paragraphs 15 and thereon through essentially 21. And related to that work, Stronghold requested a substitution initially in February 2017. There's an email from the city's construction manager that says, you didn't do it right. That's, I can point you to that exhibit, and that is exhibit I, where the construction manager says, you didn't fill out the substitution request like we did last time. Send back a letter from the subcontractor that says that they want to be substituted. That is documented. That letter is a February 28th letter, and it's documented in both the city's exhibits. I think it's exhibit 40. And that was sent February 28th, 2017. And at that point, we discovered in the litigation documents produced by the city that the city and its construction manager actually engaged in a review of that substitution request. And let me get you the yes, paragraph 20 of the affidavit and exhibit J is an actual exchange between Mr. Herreri, who was the head of the city's construction project team, and Asonio, wherein they discussed whether or not it was an appropriate substitution and whether Mr. Herreri approved it. And I would like just to point out, I mean, it's not confusing. On March 23rd, Mr. Connor passes along the substitution request from SCI and the letter from Rinaldi asking to be substituted. Says, see attached correspondence from SCI regarding Rinaldi. Do you consider this a substitution request? And if so, is it approved? Justin Connor. Bob Harari on March 23rd says, yes, it is fine. Now, that didn't end the situation because Dustin had an opinion on that. And he said in response on March 24th, to be clear, we still don't consider this an actual substitution request as required per Public Contract Code 4107. However, Mr. Harari responded very quickly thereafter. It's certainly not the best one I've ever seen, but it is adequate for a substitution request, especially with Rinaldi's letter. Further, there are more pressing issues to tend to. So that's the first one. That city approved EPD, European Paving Designs, to come in and do the pavers work. It actually approved it. Again, there's I would say fairly limited amount of correspondence that documents that approval, but it's attached to Mr. McGahee's affidavit. And then we go on to the third of the four substitution issues, and that's related to stone veneer work, which again, Rinaldi was listed for. And on April 10, 2017, SEI sought approval for that substitution. And this one's even more interesting because they asked for approval specifically to have Perry Coast Construction, DBA West Coast Construction, who I refer to as West Coast, to take over and do that stone veneer installation. And on that same day, as documented in Exhibit K, Robert Harari responds by email, including Mr. Uslar, who's head of public works at that time, approving that substitution. So not only did they approve the substitution of the stone veneer work to away from Rinaldi to another subcontractor, but they actually approved it going to West Coast. So I would offer that the position of Mr. Witry in the letter that they would never accept West Coast is just plainly untrue, as West Coast was absolutely approved, specifically related to this substitution, plus related to other West Coast work, because the project files replete with documents, including a number of requests by trade organizations that were asking for information about Perry. And there are emails from Mr. Harari, wherein he, in fact, I think the most pertinent one is January 2017, where in receipt of one of these requests from a trade organization for Perry's payroll records, West Coast payroll records, he recognizes in the subject line that it's for Perry DBA West Coast. And then in the body of that same email, he says West Coast Concrete's payroll records have been requested. So he obviously knew that West Coast is Perry and that West Coast Concrete is West Coast, and that as SEI has contended all along, it subcontracted the concrete work with the very same subcontractor it received a bid from and who had always intended to subcontract with. So again, there's just no substitution. And then moving on to the fourth of the substitution allegations, again, SEI believed that Rinaldi had all of this scope covered in its original bid, and that's why it listed Rinaldi. I want to be clear about that. It's not that SEI didn't list somebody for waterproofing, it listed Rinaldi. And due to confusion at the bid time, as Mr. McGahee will explain, and maybe I'll let him explain how crazy it is on bid day and how crazy this bid day was. But you try and confirm that you got the scope covered as best as possible, and his affidavit reflects that SEI believed that Rinaldi was going to cover all of these scopes. However, during the course of the value engineering effort, in order to allow the city to go forward with the project, because all of the bids were substantially over budget, that SEI worked with the city, Asonio, and the participants to try and value engineer stuff, which again, I will refer back to. They saved, among other things, $600,000 by working an alternate paver supplier and the paver arrangement. So the very things that SEI is being accused of doing, quote, unlawfully here now 4 years after the fact, were actually done to benefit the city and did benefit the city. But as to FD Thomas, that waterproofing scope was apparently not was not picked up by Rinaldi, and SEI performed it, but not without the city's knowledge and ongoing participation in managing FD Thomas's work. Subcontractor list of June 2016 clearly indicated FD Thomas as a subcontractor doing, I'm on section G of the affidavit, exhibit L, where it identifies the Rinaldi as, pardon me, FD Thomas as the waterproofing sub. Then later on, FD Thomas is in the middle of change order negotiations about undisclosed conditions leading to waterproofing issues and extra work, where throughout late 2016, and this is covered in exhibits N, O, and P, that give a kind of a background of the lengthy discussions and negotiations over like 7 months over additional waterproofing work that had to be performed by FD Thomas. And not only was it known that FD Thomas was doing this, but the city's own construction manager, Astonio, was asking directly to negotiate this work with FD Thomas. And I will point you to exhibit O, is where Astonio is confirming that they're getting permission to work directly with FD Thomas to negotiate this. The city was fully aware that FD Thomas was doing this paver site stonework related waterproofing, and it was actively negotiating scope changes with FD Thomas. And then, if not then, it was well known by the end of the project when additional subcontractor lists were being requested and generated, and it was clearly disclosed who FD Thomas was, what their scope was. And there's never been an objection to FD Thomas since 2016, 17, 18, 19. And then I would also point out to the fact that Mr. McGahey was asked detailed questions about this by Mr. Firstman when Mr. Firstman first got involved in this case prior to his deposition in April 2019. And despite Mr. McGahey clearly pointing out that, you know, there are, in particular related to West Coast, that West Coast, South Coast, and Robert Perry were all affiliated with similar companies, they highlighted this fact. This fact was clearly known by April 2019. And yet the city still sat on this for over a year until now they have filed or are seeking to file amended pleadings where now this is going to be one of their new 10 causes of action in the litigation where SEI is attempting to recover the money it's owed for building the city's conference center. So in essence, 3 of the subcontractors were, and one wasn't a substitution, 2 substitutions were actually approved, and the 4th was actually known, and the city engaged in assigning and negotiating extra work with that subcontractor. And then all of this occurred years ago, well outside the statute of limitations, which Mr. Firstman pointed out is appropriate in his memo. So that's the story, and the evidence is there, and it's relatively succinct in the documents. And we stand on that evidence.
I think it's very inappropriate here. We've been working towards this for 3 months, and you give us this information just hours ahead of the hearing after it's been delayed for over 1 month. What happened here?
We complied with the notice. We had to search for documents that the city didn't disclose to us. The city has emails in its files that it didn't include with its submission approving these substitutions. The city has the burden of proof, in our opinion, to establish these violations. I think it's inappropriate for a stronghold to try and disprove some purported penalty claim that's being asserted against it. And frankly, if there had been if there had been a different schedule published, we would have complied with any schedule that was provided. The hearing got delayed because somebody changed the hearing within the last couple of days, which is not compliant with the minimal notice provided by statute or the contract notice. That's why the hearing got moved.
I find
We were ready.
it difficult to find this a serious presentation. There's a lot of money involved here. And we don't have a brief from you, sir. And I'm just wondering why, with the city's letter of accusation from Mr. Wittry and an allegation that resembles an opening brief, I'm really quite surprised that there's no reply brief. Perhaps you can respond to
I- I'm sorry, are you addressing that to me?
that. Yes.
Did you see my reply brief? Well, it's not a reply, it is a response to Mr. Wittry's letter dated November 17th.
I don't see a reply brief. Do you have one? Is your letter the reply?
Yes,
Then it should have been
yes.
indicated. I mean, I agree with Chair Dawkins. You know, this is just dumping all this on us at the last second, so to speak. Sort of like, well, you sorted it out. That's not how you should really. That's not how we run this ship. No. Very frustrating, sir. Very frustrating. We're trying to do the best we can. We're trying to do the best we can with what we have.
Well, I would say that the framework was as presented to us, and we responded compliant with notices we were provided. And again, it's the city, it is a serious allegation, and the city bears the burden of establishing affirmative relief that
I understand what you're saying. No need to repeat. Thank you.
Chair Hawkins, perhaps the city, since we've taken the testimony via affidavit of Mr. McGahey, does the city want the opportunity to cross-examine that witness?
I just have a couple of questions of Mr. McGahey, if I may.
Chair Hawkins? Would that,
Well, with the late information, we really don't understand it, haven't fully digested it, and can't really do anything as a board at this point. And I'm totally lost. I'm not sure how we deal with this.
perhaps, Mr. Van Orden, it would make sense if you would like to examine your witness. I think perhaps the board had been expecting that in lieu of an affidavit.
I, for one, would like to see that.
Well, is Mr. Wittry going to testify? He's the one that is purportedly making or suggesting findings that should be made.
I mean, when we get to the city's case, of course, that's up to them. I don't know whether he's intending to testify or not, but obviously, if the city puts on no evidence of their claims, you know, that is something that the board will have to take into account.
Well, I have a problem in that, you know, the city hasn't put on evidence of a claim that should be considered.
Well, again, I believe the board's looking for evidence from your client, and you have Mr. McGahey here today regarding compliance with the subcontractor listing law, and has asked you to introduce via examination of that witness evidence relating to that. If you don't want to do that, that's your prerogative.
Yeah, I'm going to reiterate my objection to the proceeding the way it's going. I'm happy to. Mr. McGahey, do you have your affidavit handy for reference?
Yes, I do.
All right, let me ask you a few questions. In the bid list, part of the subcontractor list with your initial bid, what did you intend to communicate by writing down West Coast Concrete?
West Coast was doing all the concrete work on the project.
Who did you intend to refer to?
As far as it, I mean, it's West Coast, Bob Perry. I've always just called him West Coast. That's the way we talked about him throughout.
That's the way you referred.
And
Okay,
honestly,
so when you wrote down,
yeah, go ahead.
when the person at SEI wrote that down, let me back up. What's your role in connection with bid day?
I'm in the bid room and going through the bids, helping with the tallying, doing data entry, and just verifying numbers and, as we complete the bid. Me along with our chief estimator, Kamel Khalil.
And you've been in a number of bid rooms before?
Yes, I've been doing this for about 35 years.
And what type of work does Stronghold primarily do?
Well, we're primarily a general contractor, and we primarily self-perform electrical as well as being a general contractor. We do have some other
Okay, and
performance we do in grading and small concrete framing, finished carpentry, but generally speaking, our main sources of work are as a general contractor and doing electrical work.
okay. And when just describe how I don't know how familiar the review board is with public contracting and bid day. Can you describe generally how the bid process works after the city prepares its package to go out to bid? How do you prepare as a general contractor to submit a bid to them?
Well, as a general contractor, we would be out soliciting bids from the numerous sub-trades on the project through the different sources, whether it be Dodge, CMD, or there's numerous different trade associations, all that we work through to solicit bids. The day of the bids, because everyone knows that they're holding, it's like a poker game. Everyone's holding their cards right up against their chest. All of the subs bidding the job till 5 minutes before the job bids. And then they all, and some of them half an hour before, some of them an hour before, but the last hour before a bid, it is just absolutely, it's a mad rush to get numbers together. You've got all these subs sending faxes with their quotes and the numbers and their scope and their inclusions and their exclusions. And then some of them are sending flyers without numbers, and then they'll call in or send a final fax with the bid 5 minutes before the bid comes in. So a lot of the suppliers, like on electrical, the supply houses won't even let the cost for the materials out till 30 minutes before the bid. And so also, as we're putting together electrical or air conditioning or any trade that involves equipment, they won't even get the numbers to start doing the math on their bid till 30 minutes before the bid's due. And then they've got to put all their stuff together and get us a number. So we are on a mad dash. And that's just the way bid day is a very high anxiety. It's not for the meek to do that, but it is a mad rush right up to 2 minutes before the bid's entered to get the numbers together, to get the subs listed. it's just the way it is. It is a crazy experience if you haven't seen it in person.
Okay, now, do you do anything to make sure you write down the perfect legal name of a subcontractor who's submitting a bid, or how do you do that?
No, we normally just list, I mean, honestly, we've had them where we just listed the initials of companies. If it's, we just list just the first name. If it's for a roofing company, if it's Golden State Roofing Company Incorporated, we just call them Golden State. Or sometimes we'll say GS Roofing. You're getting across the fact that the bidder that you've got the bid from is who you're listing.
Okay, and you wrote down West Coast Concrete in the bid list or the subcontractor list that went in this bid, right?
Yes,
And who did you intend to refer to?
West Coast Construction. It's Bob Perry, West. It's the only
Okay,
West
and
Coast that
did
did the job.
And did the license number that get written down next to West Coast match the license number for West Coast Construction?
Apparently not. We come to find out that was a mistake.
And you came to find out that that license is affiliated with somebody else but related to West Coast?
Yes,
And who do you understand that license number related to?
the South Coast Concrete, who I think is.
Okay, and is that written? And as you testified in your deposition, which I think Mr. Witchery included and we included in your affidavit, that you understood that South Coast, West Coast were both owned by Robert Perry.
Yes,
Did you intend to write down South Coast's license number?
no.
All right.
And it just is, this bid our bid was protested by a second bidder. And there's these, and protested on many of these issues, these little minor tweaks of this not being correct or that not being correct. And the city at that time, they obviously had the opportunity to reject our bid and go with the second bidder and pay $5 million more to get the job done. But they decided at that time that they were without merit and awarded the project.
And just to orient everybody to the time period that we're talking about, bid day was when again?
I don't even remember.
How about month and year?
I don't even remember that. October 15, I think.
Right, okay.
I get
So we're
that?
talking about something over 5 years ago.
Yeah, I don't remember what I had for lunch, and you want me to remember a bid day in 2015?
I'm looking at the subcontractors list and you wrote Gino Rinaldi, and that's it to refer to Rinaldi. Is that their legal name?
Yeah, I don't know. And just so we understand it, and we weren't writing these in. We're transferring this information via phone to somebody that's there. We're getting these bids, and this is something else that's important to know. When this bid's being delivered in Monterey, we've actually got someone from our office that's in Monterey with the bid form without any of the numbers in or any of the subs listed. And so we're 10 minutes till we're contacting someone on the phone and they're writing this. So they're getting this over a mobile phone and writing this in and transcribing it as we're giving it all. And you got 5 minutes, we got to get this written down, and then you got to get the envelope sealed, and then you got to have it in there clocked in. So I just want to make sure when I'm not writing these down, we are transferring this over the phone to somebody who's handwriting that, who's sitting in Monterey with the bid form.
Okay. And you agree that you listed Gino Rinaldi for the scope described as stone veneer, waterproofing, and pavers?
Yes, we did.
Okay. And did you review their proposal when you got it?
Yes, I did.
Okay. And what did you understand?
Very briefly.
Okay. What did you understand that you were receiving that proposal for?
For all the stone work throughout the project and the waterproofing, and we even had one of our estimators contact them before the bid and talk to their estimator. I forgot what the guy's name is. to confirm that prior to submitting our bid.
Why did you have somebody call Rinaldi?
Just to make sure that they had everything. I mean, we were actually thinking that the number seemed extremely high for the scope of work. But we wanted to make sure that he had all of these items and confirm it, because it was the largest, I think, single trade on the project.
Okay. All right, let me ask you this. Did you consider that you, quote, substituted West Coast? Were they a substituted, non-listed subcontractor?
No, I mean, that's ridiculous, quite honestly.
Okay, and I've gone over and summarized the evidence related to the city's emails approving the substitution of work to West Coast. And I've also summarized that evidence, and this evidence comes from the emails of the city, so obviously this is not something you knew about. What was your understanding of the city's position regarding assigning work to West Coast for the stone veneer, to European paving designs for the pavers, and the waterproofing to FD Thomas? What was your understanding of the outcome of those events?
These were all, I mean, there was complete transparency in everything we did with the city and their CM on site.
And how do you know? I mean, was it documented? When you say transparency, how did you intend to be transparent with their construction manager and staff?
Well, I mean, we did the complete submittal of the substitutions and discuss them with them. Hey, this guy's not doing this. We're gonna get this, and they would help us say, well, go ahead and do the document this way. We were all trying in a very difficult situation to work together as best as possible, but it was complete transparency to the point where we were even letting them come into as you stated, we let them even contact subcontractors directly to negotiate stuff. So I think you can see that we were complete open communication and transparency on all of this and working with the city.
Did you ever, it sounds like you were operating on an oral basis, interacting with the city's construction manager and staff, did you ever receive any communication from them that they objected to the scopes of work being done by the people that did them, including the pavers, the stone veneer, or the waterproofing?
Absolutely not. Absolutely not. They were in the trenches with us on site every single day, walking the site with us, with the subs, asking them questions. I mean, I've got dailies every day. They had 4 employees on site full time every day watching these guys. They were getting daily reports from each of the subcontractors. They would ask how many guys were there on a daily basis. They'd say, well, how many guys did Bob have? They'd send us emails even say, hey, we think that Bob needs more guys on the stonework. You know, so absolutely, completely transparent cooperation between us and them and dealing with the job on a day-to-day basis.
Were there also occasions where you were required to sit down with city project management and review scopes of work or items related to these subcontractors we're talking about, European Paving, FD Thomas, West Coast?
Absolutely. We would have meetings every week, whereas both the CM and the city staff were there. This was Bob Harari was there every week in meetings with us.
Okay.
And then he was replaced by Steve Witry, who came out later on once Bob left. But yeah, they were involved in all of these, integrally involved in our weekly meetings. If you look at the weekly meeting minutes, you can see how much they were getting into the weeds on all of these and how much they were in the loop on everything that was transpiring on the project on a day-to-day and week-to-week basis.
Okay, and you raised a good point. the substitutions that we're talking about here and the non-substitution of West Coast, the correspondence in the city's files and in the documents that are attached to your affidavit are all involve Asonio or Bob Harari, but not Mr. Witry. What was Mr. Harari's role as you understood it?
He was the project manager for the city on this project.
Yeah, within the city's public works department, he was the one that ran it.
Absolutely, he was completely in charge of this project on the city's end.
Okay. And so Mr. Witry wasn't involved at all in the substitutions of European Paving or FD Thomas or West Coast, is that right?
Yes, we had very little interaction with Steve Witry until Bob Harari left. There was a couple of issues where we met with Hans on large issues that we were working through where Steve would sit in, but Steve was not at all involved in the day-to-day or week-to-week basis on this project until very, very late in the construction process when Bob Harari left.
Okay. Oh, let me ask you this. When did the stone veneer work get performed? Do you recall that?
I don't recall off the top of my pointy little head. It was quite a long process. I recall towards the last 12 months of the project.
Okay. In your in the last 12 months, in your affidavit in paragraph 23, you said that West Coast performed the stone veneer work starting on August 21, 2017. Is that correct?
That's the date I have there. Yes, it is. I did research that with our team.
Okay. And that was after the substitution was approved, correct?
That's correct.
There was a, you recall the date that you first requested substitution of EPD for Rinaldi?
I don't have the date in front of me. I could go through my affidavit and find it.
If paragraph 18 of your affidavit says that it was, you requested substitution of EPD for Rinaldi on February 13, 2017. Was that before any work was done on the pavers?
Yes, it was.
Did West Coast do any paver work?
No, they did not.
All right, that's it, Mr. McGahee. I think you answered your questions about substitution. Thank you.
May I just ask city staff, I guess? It's very unfortunate, Mr. Oram, we didn't receive this in time to really digest and understand it. And that's the fault on your part. It really is. We spent a lot of time working towards this and you failed us in terms of your time. I think this needs to go back to city staff and
I don't think so.
okay.
I think we need to decide it and give the proper weight to which this evidence is entitled. Being dumped upon us at the last minute in a disorganized fashion. I think we take it for what it's worth and go on.
Go on towards a decision.
Yes, we have the hearing. You know, it's been continued before. There's plenty of notice, plenty of time to do it. I just don't think we should continue it. For what purpose?
I feel we need the city staff to review this, which we just received, and come back to us with further guidance. I'm not sure we can do this
Well,
ourselves.
If the city agrees and if the other party agrees, you know, it would be fine with me, but I just assumed it's on. But whatever you decide you want to do, it's fine with me.
Okay.
Well, does the city feel like it's able to proceed today?
Yes.
Chair Hawkins, perhaps it would help to continue with the presentations. And then at the end, if you feel you still need more time to consider everything, we can always continue it at that point in time.
Okay.
Does the city want to cross-examine Mr. McGahey?
I just have a couple of questions of Mr. McGahey. Well, a lawyer's couple of questions, but it shouldn't take too long. If I may proceed.
Okay.
Mr. McGahey, who filled out the bid?
I don't recall. I think it was Steve Ornelas was the guy that I believe delivered the bid. I couldn't promise that's correct. He was just normally the person that ran these bids for us.
The bids are, the SEI bid is attached as Exhibit 3 to Mr. Wittry's letter. And if I may, use the screen for a moment.
You are on my screen.
Do you mean share your screen?
Yes.
Is it not letting you do that right now?
I'm
Oh, now it's doing it.
okay. Mr. McGahey, do you recognize this document? Is this the bid?
It looks like it.
Whose handwriting is that?
Again, I think that all these handwritten things would be whoever it was that delivered the bid. And you can even look, if you look at the total, you go to we're at the top there, go up higher, up higher, up higher. And see, and look, and right there, so go to item 1. And you can just see, just look at the writing there. On the handwritten, this is how close this is to the end of the job. Look at that writing where he wrote out the number. I mean, this is last minute, absolutely crunch time stuff here.
Who signed it?
It's signed by Beverly Bailey.
And whose initials are these?
There you go. So it's who,
Is that Beverly Bailey's initial?
I don't know whose initials those are.
Okay. That's fine. So,
But yeah, but obviously corrections are made and changes, but all that very last minute.
now, your letter, if I may ask you about a document. This is the bid that you received from Gino Rinaldi. Is that correct?
I don't know.
Can you let him look at the whole document, please?
Yeah. That looks like that's a ceramic tile bid you're showing me right there. Okay, there's the stone. Okay. Okay,
Is this their bid?
I believe so. I don't have, it definitely is, it looks like the proposal from them.
Okay. Now it says that they're a tile and marble company. Is that right?
That's what it says, yes.
let me see if I have this right. Stone paver exclusions. Is that what they said?
No, that, again, that's when we contacted them over the phone that day and talked to their estimator, one of our estimating team. He asked them about that and they said that they had all the stone pavers and stone veneer on the project complete. And that's why we listed them.
Now, in your subcontractor list, let me see if I have this right. License number 287169, is that? Am I reading that right?
I think so. I can't, it's very small and my eyesight sucks, but
Okay.
I want to blow that up. Yours might be better than mine. I have a detached retina, so one of my eyes is just screwed up.
Well, let's see if we can find something that'll help. 287169, Contractors License Board.
Very good.
Data current as of November 18, 2020, right before this hearing, as I was reading your affidavit. It says they're a ceramic and mosaic tile contractor.
Okay.
Is that your memory, that they're a ceramic and mosaic tile contractor?
No, they're mainly stone. That's what they do. I mean, they do mainly stone work. I mean, all these pavers were stone. This was not everything on that job that they did. They actually, the ceramic they did not do. That was done by somebody else. And all the work they did was all stone. They did not do any ceramic or mosaic on this job. That was done by a different contractor. All their work was complete stonework that they performed. They performed no ceramic tile work, nor did they provide any mosaic work on this project. If you look at the listing, there's a different person, I think, that did the, I don't know if it might have been small enough to where they weren't listed, but I know that somebody else did the ceramic tile on the job.
So they were listed for stone veneer, waterproofing, and pavers.
Yes,
And they're licensed to do but they excluded the pavers. And they excluded the waterproof membrane from their bid. Is that right?
no, again, when we contacted them that day and our estimator confirmed with them that they had that.
Okay, well, let's let me ask you a question. Do you remember, remember Exhibit 123 from your deposition?
You're gonna have to pull that up. When was that?
It's one of these Excel spreadsheets that keeps track of your subcontractor.
No, I don't remember Exhibit 127 from my deposition.
Well, I have your testimony if you want to go over that. Recognize this as an SEI document.
Sideways.
I'm sorry.
Again, I just can't read it. It is just way too small. I see a change order log on it, yes.
For the Monterey Conference Center
Uh-huh,
for various subcontractors.
yes.
And let's just take a look. And here's a log for West Coast Concrete, right?
Okay, uh-huh.
And West Coast Concrete has a a contract for concrete, shotcrete, and rebar, right?
Okay,
The amount of $2,910,062. That's what your records show.
okay,
And that's the same amount as the Perry subcontract, right?
I believe so.
Okay,
In front of me.
okay. And these records were kept by a gentleman named Mr. Ferrara, correct?
Yes, George Ranald change orders.
Okay. And George got to the job in 2017, right?
Correct.
About 14 months after the bid.
I don't recall if it was that long, that far back. I don't recall the exact date he started.
And so Mr. Ferrara put together these records based from his records. And change order he notes to Perry is for $685,000, excuse me, $685,014.26 in April of 2016 for the Wausau pavers. Is that right?
Appears to be correct.
And that's actually the same amount as is shown in Exhibit 18 to Mr. Wittry's declaration, $685,014.26, change order between Stronghold and West Coast Construction on, the date is March 2nd of 2016, received March 8, 2016. This is a change order between SEI and West Coast Construction, right?
That's correct.
And it is giving to West Coast Construction the work for the Wausau pavers in the amount of $685,014.26, right?
That's correct.
And then, but this change order to West Coast Construction, or to Mr. Perry's company, this wasn't mentioned in the substitution request to the city, was it? A year later.
No, he did not do the work. All he did, and just so you know, when we got the job, it was a bunch of value engineering. We actually had proposed that the city told us right at the bid opening that they were so far over budget, they were gonna have to cancel the project. They weren't gonna be able to go forward and they were gonna lose the money. So it was like, it was not gonna happen. And then they got back to us, I think a day or two, a few days later, and said, well, maybe we can salvage this if you can come up, help us out and give us some value engineering ideas, and maybe we can salvage this project. And so we spent a bunch of time and effort in salvaging this project so the city could have this conference center. If it wasn't for the value engineering work we did, and if we would have not moved forward to do that, you wouldn't have a new conference center.
Well, now, Mr.
So we did this value engineering, and some of the big items were the pavers.
Now, Mr.
They asked us for alternate to try to save money on anything we could, including these pavers. That was a big money item.
Now, Mr. Perry's, his company, West Coast Construction, held a B license, correct?
I believe he holds Bs and Cs. I honestly don't know, but I know he's got a B, but I thought he had a concrete license.
And the license that was listed held a D6, a concrete services license that specifically allows pavers.
I object. Can I object to that question? Because you're arguing with him over something he's already testified that was not true. They listed West Coast and they intended to list West Coast. They didn't intend to list a D6 South Coast.
I'd like an answer to my question.
What is the question?
The license in your subcontractor list
Mhm.
for the concrete work was authorized to install pavers, correct?
Yeah.
Right, go further.
West Coast didn't install the pavers. What we did though, we had them purchase the materials. That's all they did. They did not do any installation of pavers. The pavers were done by European, who was processed through a approved substitution request.
Now,
Because the lead time on these pavers, and it took the city, whatever, 3 or 4 or 5 months before we gave them the monies we could save. I think we came up with this alternate on the pavers in the building. We saved them $600,000. And we also had an alternate on the pavers in Portola Plaza that could have saved them $150,000. So the city expanded and had to
we're
afford.
going to be here for a week if the witness doesn't answer my questions.
Okay, what's your question, sir?
My first question is that West Coast Construction was not licensed to install pavers, was it?
No, they are. You
No,
can, you can absolutely.
calls for a
install-
legal conclusion.
I think you can install all of this under a B license.
Then my second question is, now, in the, towards the end of 2016, maybe the first month of 2017, your company submitted the qualifications of West Coast Construction to install the pavers, correct?
Yes,
And you submitted 5 years of evidence of installing pavers, right?
I believe so.
But Mr. Perry's company had not been operating for 5 years, had it?
Well, he had been operating, Bob Perry had been operating for over 20 years as a concrete.
Okay.
concrete
And
So-
when the architect said that the submitted qualifications were insufficient, at that point, you issued a deductive change order to Mr. Perry and hired European designs to install the pavers, correct?
No, the issue, to be correct, is that the city had a proprietary bituminous bedding that they had on the plans. And we proposed with a standard bedding like they do most pavers in the state. They did not accept that, and when they did not accept that, and they required the bituminous bedding, there was only one contractor in Northern California that does that, which is European. So they ended up having a proprietary design that we were forced to use European pavers on. Absolutely.
So when the architect rejected Perry's company as an installer, at that point, you issued this change order to Mr. Perry, change order 58, I believe, dated February 7 of 2017, and deleted the work from Mr. Perry's contract so that you could hire European pavers, correct?
No, what it was, they rejected their alternate bedding method. That's what was rejected. They rejected their proposed way they wanted to install the pavers, which was different than the bituminous bedding. They didn't reject them based on their lack of experience.
The architects Skidmore, Owings, and Merrill rejected the qualifications of West Coast Construction to install the pavers, correct?
On the bituminous bedding. That was the one they did not have the experience on.
Okay. So West Coast Construction, by the change order of the date here is March 2nd of 2016, change order 2, had been hired to procure the pavers and install them, correct?
I object. That's not, first of all, it's not signed. Second, it's irrelevant considering they didn't do the work.
Again,
That's my
all
question.
all of this was done in conjunction with the city and their CM, very transparent, daily. I lived on the job there 8 months with them, every single day, meeting with them and conversing with them on everything. We would walk the job every day for an hour. There were no secrets or nothing going on out there that the city and their CM were not completely bought in on.
My question, Mr. McGahey, in change order number 2 with Mr. Perry's company, you contracted for procurement and installation of pavers, correct?
I don't think we ever signed it, but that's what that change looks like it appears to be.
Okay. And I understand your testimony about why Mr. Perry didn't do the construction, but let's talk about the pavers that arrived on site. About 20% of them.
I'm going to object. What did, I understand where you're going with damaged pavers, but what did damaged pavers have to do with the substitution hearing?
I could have made the same objections to your narratives. I'd like latitude on cross-examination.
Wait till he asks the question before you object.
When the pavers arrived on site, about 20% of them could not be used because they were damaged, right?
Irrelevant.
You can answer.
I don't have the exact percentage, but something around that.
Okay. Okay. How about there was also a change order to Mr. Perry's company for the stone veneer work. And that was also in 2016, right?
I believe so.
Okay. But it was it's your testimony that Rinaldi, a tile contractor, had contracted to do the veneer work, right?
Well, I think you're incorrect by saying they're a tile contractor, a stone contractor. And yes,
But then you contracted with Mr. Perry's company instead, right?
yes. After we did the project, it was discovered that Rinaldi would not enter into the contract for those scopes of work.
And that was information you communicated to the city a year later in 2017, right?
I don't recall when we communicated it.
And when you asked them for substitution in 2017, you didn't tell the city that you had contracted with Perry for that work a year previously, correct?
I don't recall. Again, the main issue was the stone lead time. All of these items were done, including the pavers, to get the material, because the materials on these things were all like 6 months lead time. So the issue was getting the materials ordered, because they were so long to get those that had to be done very quickly.
Okay.
We prioritize our issues with what needs to be addressed now, and if the stone's not going to be on the job for 6 months or whatever it is, yeah, those issues are prioritized. But again, every week, every day, we're talking with the owner and complete communication on every aspect of this project.
Okay. Let me just switch for a moment. You were deposed in this case on April 17, right?
It appears to be.
Of 2019.
Mhm.
And I was the deposing attorney.
Let me see. I think so. Yes, you were.
And I was. And this was a week or two after your company had produced documents to the city, correct?
I don't recall how that transpired between documents and my deposition, what the dates were between those.
But it was around that time. It was in the early spring of 2019, correct?
I'm.
No, I object to that. I
not
disagree.
those dates. I'm not, I can't commit to those dates.
Okay, and now in that deposition, let me see if I have this right. On page 24, line 15 to 25, you were asked about the records showed West Coast Concrete, but I believe you intended to write South Coast Concrete, and they were replaced with, is it Perry Concrete? Does that ring a bell? That was my question, right?
Okay.
Not the most artful question, but that's how I framed it. And you said, I think those are all the same, one and the same company, right?
Well, it's all Bob Perry, so yes, in that respect.
Okay. Let me ask you a question just about concrete. For concrete, you need formwork, right?
Yes,
And rebar.
sometimes not.
And you also need the concrete, correct? Okay. Okay. Let's see.
Site concrete, a lot of times doesn't need rebar.
Let's talk about FD Thomas. What was the total amount of the subcontract that you had with FD Thomas on this job?
I don't recall, it was 200 and something, I think. It was 200 something thousand dollars.
Go back to your change order log. We can. And let's see if we can find Thomas. There they are. FD Thomas had a base contract of $235,000. Is that right?
Appears to
Is that what it
be.
shows? And that was about $1,000 under the 0.5% of your bid. Is that right?
I don't recall. They were replacement for listed sub.
And there were change orders to that subcontract of $509,831.
It appears so.
Do you know where the records are of the FW Thomas subcontractor file?
No, I don't. It's somewhere in our archives, I would assume.
Yeah, I don't know either. Okay. Question. This is, I believe it is Exhibit 8 to Mr. Wittry's declaration. It's a submittal to Mr. Connor from Stronghold Engineering, and the title is Contractors, Labor Rates and Sublist. Do you know what this is?
Like a transmittal cover sheet.
And do you recognize this document, the Monterey Conference Center listed subcontractors? Is this a document that your company prepared?
Yes, I believe so.
Okay. And this is in January of 2016? January 19?
Okay.
So it's 3 months after bid day.
Okay.
And you're still showing Gino Rinaldi for stone veneer, waterproofing, and pavers.
Okay.
And you're also showing a company called West Coast Concrete, right? At wccconcrete.com.
Okay.
Is that right?
Appears to be correct.
And then when we go to the back for West Coast Construction, it's kind of hard to make out that license number, isn't it?
For my poor eyes, it's absolutely impossible, but
But the www West Coast Concrete, now that's, or wccconcrete.com, that's pretty prominent, isn't it?
I can see that, yes.
Okay. And this here, this is exhibit number 6 to Mr. Witchery's declaration. This is the proposal that you received on that you received from West Coast Construction for the concrete work, right?
I can't tell, I don't see the quote, I just see this, it's like the cover sheet for it, yeah. Okay, yeah, that appears to be the quote.
Okay. And this is the bid that you had on bid day. And this is the basis of the name on the subcontractor list of West Coast Construction. Is that your testimony?
I believe so, it appears to be not very similar. Yeah, 'cause I see it's got Camel's markings on it, so.
Where does this contain the license number that was placed on the bid?
I don't know. I can't see the license number on this either.
$857,992.
Okay.
Where did that other license number come from?
I don't know, just a mistake, obviously.
And this is Exhibit 7B to Mr. Witchery's declaration. And this is the subcontract between West Coast Construction and Perry Coast Construction. Is that correct?
No.
Is what now, I'm sorry?
This is the subcontract between West Coast Construction and Perry Coast Construction. Is that correct?
Subcontract between Stronghold and West.
I beg your pardon. I beg. Exhibit 7B to Mr. Witchery's letter is the subcontract between Stronghold Engineering and Perry Coast Construction, correct?
Yes,
Excuse me?
West Coast, yes.
Okay. And this is a subcontract for concrete work, correct?
concrete, shotcrete, and rebar, yes, appears.
And I believe you've testified already about the use of the name West Coast Concrete during the job. And we've covered the pavers and stone veneer. Ask a question about what was the work that FD Thomas ended up doing? What was their total scope?
Oh God, I don't recall everything I know that when the owner was doing that direction with them alone, direct, when we agreed to allow them to work direct with FD Thomas, that I think they negotiated like couple hundred grand almost to waterproof there's a underground duct there under the building that kept filling up with water. And then the other thing was I don't recall all the changes, but they
Darrell,
a lot of the waterproofing.
can we take a break soon?
Sure, we can take a break. This would be a convenient breaking point.
Darrell, can we take a recess maybe?
Sure, that's fine with me. 10 minutes.
Thank you.
I'll be here.
Okay, so the time is 3:57. We should be back at 4:07.
Thank you.
Hello, this is Darrell.
I would like to show you what I believe is your first payment application. I would like to show you. This is Exhibit 1 to Mr. What I believe Mitchell's declaration is your first. Recognize this as your first pay app on this job, Mr. Mitchell's declaration is your first. Recognize this as your first pay app on this job.
Make that bigger.
Mitchell's declaration. Recognize this as your first pay app on this job.
Make that bigger.
Doing the best I can.
Be the first one.
In December of 2015, doing the best I can.
Be the first. It appears to be.
And it has a schedule of values. December of 2015.
Appears to.
And the scheduled value for waterproofing was 250,000. Is that right?
It appears to be.
And was there a scheduled value for waterproofing on Jeffers Plaza? Is that right?
Appears to be. I don't recall.
And was there a scheduled value for waterproofing on Jeffers Plaza? Is that right? Now, the bid. And was there a scheduled value for waterproofing? If one includes Jeffers Plaza, the 1/2 of 1% threshold was, I believe, $236,000. Is that about right?
So.
Okay. But if Jeffers Plaza was excluded, then the threshold was down $233,000 or so. Is that right?
Whatever it would be. I don't know what the amount would be.
Okay. And you attached a subcontract agreement to your declaration with FD Thomas, Exhibit L to your declaration. Is that right?
Yes.
And it was for $235,000, right?
Yes.
Was this ever signed by Beverly Bailey?
I believe so. I would assume so, but I don't know.
And if I understand this correctly, we're looking at Exhibit 124 from your deposition. Remember this? This is another one of your subcontractor logs.
No, I don't. I can't read that at all, though, too. If you want to blow that up, I'd appreciate it. Thank you. Okay, it's the grading guy. Okay.
Master change order, you recognize the Monterey Conference Center job?
Yes.
Okay. And you recognize subcontractors from that job?
I'm recognizing some names of that, yes.
And one of them here is FD Thomas, right?
Yes.
And it says, alternate ad, provide all waterproofing at Jeffers Plaza for $245,000. Right?
Is correct.
So if we construe the FW Thomas subcontract amount as including Jeffers Plaza, it's the $235,000 on the face of the subcontract and $245,000 in this first change order for Jeffers Plaza, correct?
With that change order, yes. That wasn't approved by the owner for like many months after the job started.
And the owner change order issue date was May 17 of 2016.
Years.
And what was the date of the subcontract with FD Thomas? Received it May 16 of 2016.
Looks like it was April.
I think this says May up here.
That's when it probably came back. So I'm going on the date, that it's the actual date on the contract says April 2016, April 5th.
Mhm.
And I think what you're seeing is probably when it was signed and brought back. I'm guessing that's, contract was issued, it looks like April 5th. If you read the agreement, go down to the type part.
Mhm.
I think that would be the date the contract was issued, would be my guess.
So it says 235,000 and an alternate ad for Jeffers Plaza add 245,000, correct?
Correct?
And that alternate ad was issued when?
I don't know, it looks like it was after that sometime that the owner approved the change order to add that plaza into the project.
Do you remember the date?
No, I don't.
Okay. So if we calculate this subcontract amount without the Jeffers Plaza amount in the bid, it's over the 0.5%, right?
Yes, but we listed somebody else on the waterproof in this.
Rinaldi. The tile work contractor, right? Okay. That's all I have. Thank you.
Thank you.
I got a couple follow-up questions. Can somebody give me control of the,
Oh, here, wait, sorry. Let me. Okay.
do I have control? I don't know, Karen, I don't know if I'm waiting for you or somebody else.
You should be able to. I'm sorry, Karen. Go ahead.
So share screen, is that right?
Yes.
Let me see if I can find the right. Tell me, see, can you see my screen now?
Yes, it says West Coast Construction.
Okay,
Okay.
all right. Mr. McGahey, this was Exhibit 6 that Mr. Firstman was just showing you, which is the proposal of West Coast Construction with their domain name WCC Concrete, westcoastconcrete.com. Is that correct? Okay. This is the first page, but I want to show you page 3 at the bottom here. Do you see this? I don't know if you can see that highlighting on it or not, but
I can see West.
do you know who Danny?
Yeah, I can see that, or Danny Mokdad, the estimate.
Yeah, you know him as the estimator of West Coast Construction. Okay, so Robert Perry, DBA West Coast Construction. Danny Mokdad is the estimator, right?
Yes,
Okay.
or it was.
All right. Let me show you Exhibit 8, which Mr. Firstman also showed you, which is an older list of subcontractors, January 19, 2016. And let me ask you a question first. Had you signed a subcontract with Rinaldi or West Coast at this time?
I don't recall if they were executing contracts or not at that time.
Okay, this is right after the project started. Is that correct?
Yes, the project started, I think, in November.
Late December, mid-December. Let me take us down here to this page that lists West Coast Concrete, and we see their scope. You already asked questions about it. Do you know of any other Danny Mokdad that works for any other contractor other than West Coast Construction, Robert Perry?
No,
No. So this is the same Danny Mokdad, Danny at wccconcrete.com, that is associated with West Coast Construction, the subcontract you intended to list, correct?
yes.
You ever get any questions back from the city as to who West Coast Concrete was in January 2016?
No, we did not.
You also got asked some questions about Jeffers Plaza. Was the Jeffers Plaza scope of work something that the city added to your contract by change order after the work started?
Yes, that was one of the VE items they were looking at, potentially not being able to afford doing that. So,
So what was the discussion during that VE process?
well, they put everything on the table. They said they were basically like 10 million over budget, and they wanted to see if we could figure out a way of saving 10 million. We told them, doubt it very seriously, but if we make some major cuts, we'll do everything we can to make this project come to fruition for you. And I think we initially came up with about almost $8 million in proposed savings. And they, at different times through the project, would accept some and not others. And this was one they pushed off for a while because they didn't know if they were going to have the money to do it.
And so when was that added by change order to the contract
I think he was saying in May.
of 2016?
Yes.
Okay. So until that point, no work was being done on Jeffers Plaza until you had a change order authorizing you to proceed.
Yeah, they were absolutely adamant that at that point, that was going to stay just the way it was.
Let me ask you this. I'm showing you what is Exhibit J to the submission that we submitted, and here's the email exchange. This is between Robert Harari and Dustin Connor, where I read earlier that Mr. Harari confirmed the substitution of Rinaldi is not the best he's seen, but it's adequate for a substitution request, especially with Rinaldi's letter. Had you ever seen this email during the course of the project?
No, I haven't.
Had you seen it up until I showed it to you in connection with preparing for this hearing?
No.
Back to Jeffers Plaza, do you have an understanding as to whether the listing law applies to work added by change order to a contract?
No, does not.
Meaning the listing law does not apply to change orders, correct?
Right.
All right, for the hearing board, I'm going to reference Mr. Wittry's letter, actually, the letter in connection with this matter, the first one. He lists out the listing law code sections, and on the pages aren't numbered, but it is section 4107, subsection C, which addresses the exception of change order work from the listing law requirement. So in other words, Mr. McGahey, under your understanding, adding the Jeffers Plaza to your contract meant that you could add that Jeffers Work Plaza to FD Thomas without having to do a substitution or otherwise comply with listing. Is that right?
Correct.
All right. And All right. I'm showing you what is Exhibit K to your affidavit here, which is the email chain, an attachment related to the city's approval of West Coast performing the stone veneer work pursuant to a substitution. Let me just show you the whole email here. And who's Heidi Whitehurst?
She was in our contracts department.
Okay.
In our office.
All right. And then she sent on April 10, 2017, the full attachment, which was your substitution request that is, I think, contained several times in the exhibits. She sent that to Bob Herrera, who responded on April 10, 2017. The city approves this substitution. You received this email correctly, is that correct?
Yes.
And Uslar at Monterey.org is who?
That'd be Hans.
And in 2017, was he the Director of Public Works, to your understanding?
Yes, and he was, title was, I think, interim because it wasn't official or something, but yes.
Okay. Mr. Firstman also showed you some change order related to deductive work. You referred to in your affidavit a deductive change order, and I'm showing you what is labeled as change order number 22, dated May 22, 2017, Perry Coast Construction, Inc., DBA West Coast Construction. Change order number 22. Have you seen this before?
Yes, I have.
And it has a negative $272,965.51. What does that signify?
That was the deleting the labor portion of that site pavers change order that was previously issued.
Okay, and what was the purpose of issuing this deductive change order to West Coast?
Because we were utilizing European pavers with the that could do the bituminous sub installations on the pavers. So this was to have European pavers do the installation of all the site pavers.
And, you know, there was ongoing discussion about all of these paver changes and substitutions and value engineering with the city. Is that right, over a course of time?
Yes, I mean, again, we were every day meeting with them, discussing issues.
All right, I'm trying to show you exhibit here. All right, I'm showing you what was attached as Exhibit C to your affidavit and submission. What what did change order 2 between the city and SEI address? Generally.
Well, it had a bunch of deducts and cost savings issues that were part of our VE items that we had proposed to them. And then they did add some traffic signal work that they were gonna do themselves, but they told us to purchase it.
So for instance, item 2, delete BIM modeling requirements. Negative, subtract $49,159 from the contract. That was a value engineering item.
Yes,
And the date on this is March 8, 2016. Does that match your memory as to the general time period in which this change order was agreed to?
yes, I believe so.
So here we go down, item number 6, RFP 11, substitute granite building stone requested by City of Monterey. A reason alternative supplier provided a similar product for a reduced price of minus $602,130. What does that relate to?
That was changing the stone material from a specified material at bid time to a product that we went out and secured that was very similar to get the city that cost savings.
Okay, so between the time of your bid submission, award, and start of the contract until March 8, 2016, you were working with the city to help them reduce the cost of pavers. And this is the credit you ended up giving them and the benefit that they got out of all of that negotiation. Is that right?
That's correct.
Okay, and part of that was also divvying up the work assignments between Rinaldi and EPD and so forth, ultimately, correct?
Yes.
I would like to, oops, I didn't mean to do that. Can I just take it back? All right, this last exhibit is, as it's labeled, a Stronghold Engineering versus City of Monterey, Santa Clara Superior Court case number 18 CV 329015 privilege log. I will represent that this is a privilege log that was provided by the city attorneys. We're marking Antonio documents as privileged, and right here on the very first page, among other pages, that the name Karen Salama shows up. And if I do a control find, I can go find a number of these, page 83, more, 108, again, with an asterisk indicating that she's a city attorney. Again, 125, 143, and then she's listed as one of the city attorneys for which privilege is claimed. And I just got to introduce that into the record of this proceeding as we go forward. But as of that, I don't have any more questions of Mr. McGahee.
Could you stop your screen sharing then? And again, I'll just say for the record, those likely were emails with staff from years ago. I have not been communicating with anyone in the Public Works Department regarding any of the subcontracting issues that are before the board today. So with that, I believe, Mr. Firstman.
I just have really, this time, just a couple of questions about what the witness just testified to. If I could control the screen for one moment, that would be appreciated. Okay, I'm trying to understand how I get this to work now. apologize, I'm not.
Do you see the share screen option?
I do, but okay.
Oh, it did it.
Okay, there we go. Mr. McGahey, I believe that you and Mr. Perry were talking about, what did you call it? A bituminous base?
There's a bitumen sub base that this was sat on.
Okay,
There's a small, I think it was between a 1/2 and 3/4 inch thick layer of asphalt that you lay down and then you set the pavers directly on asphalt, which I've never seen done before in the state of California.
okay,
That was the deal.
okay. And you were corresponding with Mr. Perry about this in the fall of 2016, right? And asking him, can we do it this way?
This is a totally different deal here, I think. This is the base section underneath all of that. This is a totally separate issue.
Okay, well, how about this one? Let's see if I can. This is November 22nd, and
There's that bitumen section.
there it is. And Dustin, he's with the construction manager, right?
Yes,
For the city.
yes.
And he writes to you, to Tim Jackal and Sam Phillips with a copy to a number of different folks, and says, the city has agreed, right?
Mhm.
And part of what and I'm glad we've come to terms on this item and we can move forward, right?
And the issue just, again, it's not, the issue that they came to terms with was it called for a concrete treated base underneath all of this. And in lieu of that, we went ahead and installed a flex concrete mix, which is a much more expensive and structurally sound product for them. That's really what this was all about. And the previous email, they had a product specified on the plans originally that they come to find out would not work because of the tight constraints of the plaza and the size of the equipment needed to do it. So they changed it from concrete treated base, which is just a cement treated rock. And we went ahead and put in the 650 PSI flex concrete underneath all of this. That was really what the previous email and this one was all about, because that was, again, a lot of brain damage to get their original design intent, which they finally figured out was possible to do, and change it to something that was constructible. And as you can see there again, it's all the cement. This is all about something different.
Okay, so this is in November of 2016. The email here from Mr. Connor is in November of 2016, right?
Okay, yes.
Okay, and then 2 months later, you submit to the city the qualifications. So this is on January 11 of 2017. You submit to the city to submit to the architect the qualifications of West Coast Construction to do this stonework, right?
All right.
And it goes on about 5 years of their experience, even though they hadn't been in business for 5 years, right?
Well, again, they've been in business doing concrete for over 20 years. Perry has.
Now,
They're installers here. I think that was the key, is their experience for the actual installers.
and
Meet or exceed the requirements.
And Skidmore responded to you that even these qualifications did not meet the specification, correct?
No, again, I recall that it was tied to the bituminous coatings. The bituminous layer was my recollection, but I don't have any of the data here on it, nor have I investigated it.
Okay.
At the end of the day, obviously, European did the pavers with the bituminous setting bed.
I have no further
All
questions.
processed with the city and approved by the city.
Okay. And Rinaldi didn't do it, did they?
Rinaldi did not do that scope of work.
Okay. I have no further questions.
Okay, so if we're done with that witness, did Stronghold have any other witnesses?
No.
Okay, then at this point, I think we can move to the city's presentation in chief.
Okay. If I can, I'd like to ask Mr. Whittree to take the stand. I'd like to call Mr. Whittree if I could. No, I'm not sure what we call it in the Zoom world. Or to
Oh,
take the screen.
I think you're still sharing, Eric.
Who was sharing before?
Oh,
The screen, please.
there we go. Apologize.
Do you want to go ahead, Mr.
Oh, yeah.
Hirschman?
Yes,
Okay.
I just wait for the court to tell me to proceed. So, okay. Good afternoon, Mr. Whittree. Could you tell us your name, your position, and what you do?
Certainly. Steve Whittree. Currently, I'm the Public Works Director and City Engineer for the City of Monterey. I've been in that role since about 2018.
Okay. And can you tell us your relationship to the project?
Certainly. As was been discussed, I became the city engineer right around 2015. Bob Ferrari was working for me at that point in time when I became a city engineer. Bob was the project manager, and I was the lead of the engineer division, which Bob was part of.
Could you speak up, please?
Oh, sorry, a problem. Yeah, it's been late in the day. I apologize. So basically, in 2015, I became the city engineer, which is in charge of the engineering division. The engineering division oversaw the construction aspect of it. Bob Ferrari was part of the engineering division at that point in time. Essentially, my role was to make sure that the entire engineering division functioned, and Bob was assigned the primary role of project manager for the construction of the project. Bob decided to go to greener pastures, if you will, took a job with the city of Carmel. And let me check my note here. And he actually retired or left the city in June 17th of 2017. At that point, I became the main contact for the conference center to try to get the project wrapped up and completed and fully constructed.
Okay. Can you tell us just briefly for the record here, just for the written record, about the project? Who was the contractor? When did it start? When did the contractor leave the site? Just so we have that in the record.
Yeah, in essence, the contract was bid in late 2015. Contract was awarded by City Council. The primary contract was Stronghold SEI, as we've been calling them. They awarded the prime contract at the end of 2015. The project was under construction for approximately 2 years. It consisted of the renovation of an existing conference center. The current conference center, or the previous conference center, was about 25 years old, and this was an extensive remodel of that conference center and the entrance plaza, Portola Plaza, as it's called. Like I said, SEI was the prime contractor. In spring of 2018, the construction was done, and the city took beneficial occupancy.
Okay. Now, just in general, what is your understanding of the listing law, of the subcontractor listing law?
So the subcontractor listing law is part of all public works projects. Contractors are required to list subcontractors who will do more than 0.5% of the work. In my generalized way of looking at it, it's basically to protect the city and the public and public dollars, to ensure that the contractor has done its due homework in taking major portions of the job under consideration and having an idea and disclosing who will perform major works, in this case over 0.5%. And it's to protect the public and to protect the city.
Okay. And we've gone over the subcontractor list and the bid. If I could ask, could you tell us a little bit about the overall scope of the concrete work on this project?
So it was pretty extensive with this project. Essentially, there was a lot of demolition that had to occur. The actual floor space was expanded. There was structural concrete that had to be poured, beams that had to be poured, as well as a deck where the conference center sits, the lobby, and so forth. Very extensive concrete work was going on throughout the project, and it required, the project required a skilled set of hands to do that.
Okay. Did you ever become aware that there was no company named West Coast Concrete?
During this whole process of preparing the letter, I became aware. During the construction project, no.
Okay. Mr. Perry's company had a general builder's license. Does that matter to you when we're talking about a subcontract for the concrete work on the Monterey Convention Center project?
Once again, as a working knowledge that I have from doing this for 20 years or so, basically, if the Class B contractor was going to perform work, it would be something along the lines of, a driveway or a sidewalk or something like that, not structural work. Typically, structural work is done with a C8 or an A contractor.
Okay. Is that a concern to you that you have a general building contractor responsible for all the structural concrete?
It certainly is, especially with, like I said, there's a lot of structural concrete going on there. It's making sure that the concrete is around the rebar. For those who in the general public, general knowledge, when you see a concrete beam that supports a floor, a grand portion of a large percentage of that is actually steel, reinforcing steel that's encased within that. Making sure that that concrete binds with that steel and performs a solid unit is vitally important to the integrity of the building. And then, we're an earthquake country as well. We want to make sure that we have good concrete structures that are not going to fall.
Okay. So I just want to make clear, the first time that you learned that SEI contracted with Perry Coast Construction for the structural concrete work was when the listing law issue was brought to your attention in the last few months, right?
That's correct.
Okay. Now, we've also talked about pavers, and with that, I'm trying to not repeat information that we've already gone over with Mr. McGahey. So if there's something foundational that I've missed, but I don't think so, I'm just trying to fill in the gaps here. about the pavers, can you tell us, can you tell us about the paver work on this job? What was it and where was it?
So to frame it a little bit better for context, the original contract, original Portola Plaza, as it's called, had brick pavers. They continually failed. There was potholes, there was issues with them failing, they were cracking and breaking, they could not support the weight. That was a really big concern during the construction process, and we wanted to make sure during the design process, we wanted to make sure that there was an adequate support layer for the pavers. The pavers are, if you've seen the conference center, they're the circular driveway and the truck loading zone where vendors will come in and bring big semi trucks to load their equipment into the conference center. So they have to support a lot of weight. Around the turnaround in front, the circle driveway, also heavy vehicular traffic. We didn't want to have any kind of situation where we're repeating this issue with failing pavers. So to do this process per the specs, we had a very thick section, a very sturdy section of paver from subgrade, which is below the paver installation, through the installation layer, which is the bituminous material, and then the paver itself. All together, work together to form a stable foundation that would resist failure due to trucks and loading.
Okay, now tell us about the pavers when they were delivered to the site.
There was an inordinate number that were broken. There was a lot of discussion that had occurred. Now, once again, I was being kept on the loop. Sometimes I was at meetings, sometimes it was being let know from Mr. Harari, so it is a little bit hearsay in that aspect of it. But what I do recall is that the pavers had a long lead time, and we were very disappointed that many of them came back broken.
So they got to the site and
they were uninstallable. They were not installable. And like I said, there was a long lead time with these processes. That's what we were told. That's what we understand. It's true to this day for replacements that the pavers are a long lead time. And it was very disappointing that many, I don't recall the percentage, but many were damaged and not installable.
okay. Let's talk about waterproofing. Can you tell us about the waterproofing on this job?
So the waterproofing is key. Obviously, you want to keep the weather out. Very important for us to make sure that we're keeping our guests dry. The waterproofing had some issues during the construction process, and we had some failures of the surfaces, and the project was flooded out on an occasion.
I'm going to apologize, but for every moment that I'm spinning through the questions, we're saving about 10 or 15 minutes of.
I appreciate that.
So attached to your declaration, exhibits 9 through 16 are various project documents that referred to West Coast Concrete, if you recall those.
Mm-hmm.
And
yeah.
I think that Mr. McGahey talked about them as well. Do you recall at some point the city received a Public Records Act request, I think at the end of 2016, asking about Perry Coast Construction?
I actually do not recall whether they did or not. I wasn't at the level to deal with that actually. It came in as an information request, I'm assuming, but I don't have any information about that.
Okay. Okay. Did you receive any follow-up on that from the Department of Industrial Relations?
So very recently, we have received some follow-up from the investigation that the Department of Industrial Relations has done. And they found that there were some not proper dealings with certified payroll, and they fined them in excess of $2 million for work according with this project.
So Are you able to tell from the order that you received if Perry was paying less than the required amount, but you were being charged for the required amount?
That appears to be the finding from the state, that they were not paying prevailing wages as the contract required.
Okay. Talk about waterproofing for a moment. You received some warranties from SEI. And I think they're at Exhibit 28, 28A. You received some warranties from FW Thomas.
Yeah, FD Thomas, yes.
Okay. What do these warranties indicate to you?
They indicate that they perform the work. There's no reason to warranty if you're not performing the work.
Okay. Let's talk about exhibits 21 through 27. And let me ask some questions. Do you recall Mr. Perry's company, or West Coast Concrete? Well, here, I'll rephrase it. Do you recall that whoever was doing the construction for, strike that. Let me put an exhibit up. This document from the SEI files in September of 2016, and it's with Mr. Perry doing business as South Coast Concrete, according to the email. But he's talking about hitting cables while they are working out in the Portola Plaza. Do you recall those incidents?
Not specifically, no.
Nope. Okay. How about the subject of water damage? Do you recall water damage?
Oh, I apologize. There was a plumbing line that was struck that I was aware of. If that was what you're referring to. I don't have the exhibit in front of me. I apologize, but there was a plumbing line that was struck in front of the hotel that caused some flooding. Is that what that's referring to?
Let me.
Yep.
If I could take the screen. Do I have the screen or?
I think so.
I don't believe anyone's using the screen.
There we go. Do you recall in January of 2017 problem with water damage to the project?
Yes.
All right. And this is, I believe, a 20-page letter that went to SEI. Is that right?
Correct.
In your own words, can you tell us what happened?
The site was not protected from water. Frankly, we had rain. It was rain in January, and the site was not protected, and water infiltrated the entire project. The previous screen that you had showed the extent of where water intruded into the building and the site. It was cause for substantial delay and substantial disappointment for the city in terms of the delays it was going to cause, as well as some damages that occurred to the hotel property, which we had to work with our partners at the hotel to try to resolve.
Okay. See if we can find, here we go. Is this the hotel that we're looking at here? This
That's
photo on page 11?
Yeah, it's a service corridor that serves between the conference center and the hotel. It's one of the back roads, if you will, that allows the hotel to serve guests and provide catering and such services and set up and tear down. And that is an area that was obviously inundated with water.
Okay. Do you know what subcontractors were, whose work was touching this water infiltration problem?
Not specifically, no.
Do you know the trades?
So it's a waterproofing trade. There would be the connection to I believe this is below the Jeffers Plaza work. And it would be failure to provide an adequate membrane from the roof above. The ceiling in that surface corridor is the Jeffers Plaza, so somehow water's coming down through that construction site up there.
Okay. And what did this do for the relationship with the hotel?
The relationship with the hotel was actually tenuous from the process. The problem that really started was the delays, and when there's issues and delays, and then there's things like this that exacerbate the situation, it makes a tenuous situation. And although we attempted to resolve it, and we may have resolved this one, it may have been a straw that was on the hotel's back, and eventually they filed suit against the city.
Okay. That's Exhibit 22 to your declaration.
What declaration?
Excuse me, to Mr. Wittry's letter, I beg your pardon. Here's a letter or an email of June 22nd, 2017, and this is from the SEI files that we received from SEI. And it's to West Coast Concrete, Inc., and it says that they're in default in June of 2017, which I think is around the time that you were assigned the project when Mr. Harari moved over to the city of Carmel.
Yes.
Do you recall problems with the progress of the concrete work?
So I knew there was issues with concrete, but I did not know that the relationship between SEI and West Coast Concrete had gone to a point where they were at this point of disagreement.
Okay. Okay. If I can move over to Exhibit 36 to your letter, which is, we've looked at it. This is the bid from Gino Rinaldi, Inc., Tile and Marble, to SEI. We've just put some red arrows. What was STN3 and STN4 pavers at Portola Plaza? Recall that?
STN3 and STN4, I don't recall, but pavers at Portola Plaza are the pavers for the automobiles that circle around the fountain and the truck loading area that I spoke of.
Okay. All right. And
So for clarification, Mr. Firstman, your firm put these red arrows on these documents?
yes, we did.
Did your firm prepare the letter that Mr. Wittry submitted?
This is not my deposition, Mr. Van Ornum.
It's true.
If we could look at Exhibit 40 to your letter, which is the substitution request of Gino Rinaldi for the vehicular pavers of February 28. Do you recognize this as a letter submitted by Stronghold Engineering to the city?
Yes.
Okay.
Yes.
Were you involved in evaluating this substitution at all?
No.
Okay. Now, Rinaldi says the scope requires a bituminous setting bed with a 2% modified neoprene tack coat and swept joints. Do you know whether pavers are within the scope of a tile contractor's work in the first place?
Generally not.
Okay. Were you informed about this substitution request?
I knew there was discussion of a substitution request. I attended one or two of the meetings that it was discussed. There was a challenge because it was a non-standard, as Mr. McGahey pointed out, way to install pavers. However, it was something that our architectural firm had had success with at buildings in San Francisco with similar soil properties, and that's why it was recommended. So that's where the bituminous underlayment came from.
At any time, did anyone from Stronghold tell you or anyone else at the city that you know of that Perry was under contract for the pavers?
No, there was no mention of Perry being under response for the pavers. The discussions that I recall being at a meeting of was that they were a unique kind of paver installation and required special contractor to install it. I don't recall names being thrown about who was trying to do it or who was supposed to do it. I do recall that European Paver was mentioned as someone who could do it.
If we could look at Exhibit 41 to recognize, there it is, Exhibit 41 as a letter from Stronghold Engineering to the city.
Yes.
And this is substitution request of Gino Rinaldi for the stone veneer.
That's what it says, yes.
Did anyone at Stronghold tell you that they'd contracted with Perry almost a year previously for the stone veneer?
No.
Now they attach a letter from Rinaldi Tile and Marble. And it says, it's dated April 5 and says it's outside of their expertise. Do you recall receiving this letter?
I recall seeing it in the file, but I don't recall seeing it at the time.
Okay. All right. Let's have you reached any conclusions about whether SEI violated the subcontractor listing law by listing West Coast Concrete with a license number that belonged to a company named South Coast Concrete, and then contracting with Perry Coast Concrete, having a different license number?
Yeah, I think that there's too many small errors to avoid the conclusion that something was done here that just, there was no attention paid to it, and there was no forthright attempt to have happen. You know, I do appreciate that bid days are busy and things move forward, but these are professionals who do this for a living. If they didn't do it properly, they would not be in business. Listing the contractor's license number incorrectly, that's something that really needs to be corrected as soon as possible. As soon as noted through the process, it appears that there was no attempt to correct it. There was communications, and it was just brushed upon, brushed over. So I think that there's a violation of the law, of the listing law, because it didn't provide the appropriate tools available to protect the city and public interest.
Okay. Let me be clear. SEI never told the city that they were using a concrete subcontractor who only held a general building license and was not the company they had on their subcontractor list, correct?
That's
That
correct.
seems- that seems bad.
We assume we had a concrete contractor.
Okay. Now, did you reach a conclusion about Perry's contracting, excuse me, strike that. Did you reach a conclusion about SEI's contracting with Perry for the pavers and the stone veneer in 2016?
So I mean, I think that what's clear is that they never intended to have Rinaldi do the paving work. That's on their quote, and they had assumed somehow that West Coast would do that work. Back in the documents, the subcontractor list, that's not listed under the work that was going to be performed by Perry or West Coast Construction or West Coast Concrete. I think there's manipulation, if you will, of those documents.
Okay. So you found a violation, right?
Yes.
Okay. And the waterproofing, looks like their total value of their contract with FD Thomas was over $800,000.
That's what it appears from the documents, yes.
And they were not on the subcontractor list, is that right?
They were not on the subcontractors list, and I think that just to add a little bit more to the conversation regarding Jeffers Plaza, Jeffers Plaza was listed as a deduct, not an additive alternative in the bid documents. Therefore, the cost associated with that deduct, the contractor has no way of knowing whether the city is going to accept that proposal for the entire work or not. So when you look at the deduct for Jeffers Plaza, the intent of the city was that the contractor would have those subcontractors and those subcontracted listings, including the value of the Jeffers Plaza.
Okay. Did you find a violation of the subcontractor listing law?
Yes.
Okay. And I believe you made that finding in your letter of several months ago. Is that right?
Yes.
And have you made a determination of the amount or the percentage of, that you will assess?
As I understand the law and this penalty portion of it, it allows a maximum of 10% of the contract value. I think that as we're looking at what they've done here, and what they've done is create a confusing atmosphere. This is a very complicated project, and it has very tight timelines, and it had to have clockwork precision to be run properly. I think that because of all the background information that was going on, there was this confusion that was created, and this confusion by not being forthright, as was mentioned by Mr. McGahey. I don't believe there was a clarity there. And because there was no clarity and intentional confusion, it cost the city and it cost the project and it cost the public. And therefore, I think it should be at the highest level that's allowed by the statute, which is 10%.
Well, Mr. Perry's work caused the city a lot of problems, right?
Yes,
And appears to have caused the contractor problems as well.
it appears so based upon some of the documents, yes.
And I believe what you've done is you've only focused on the larger violations.
That's correct.
Okay, so the Perry subcontract, the original value was $2,910,000, and 10% of that is $291,000.
Yeah, 2,000,009 and 291 is the math, I think, yes.
Okay, and that's the penalty that you assess.
Yes,
And the paver change order, we round it to $685,000. And 10% of that is 68,500.
that's correct.
And the stone veneer change order value was 277,300. And you assessed a 10% penalty on that amount of $27,730.
Correct.
Okay. And then on the waterproofing, the records that we had, it indicated the amount of the subcontract was about $500,000, but it looks like as we look at the records more, it's over that. But I believe the penalty that you assessed was just the 10% of $500,000, right?
We did a rough estimate that it's more than likely more than that. We're trying to be conservative on that aspect of it, and we estimated 500,000, and 10% of that is 50,000.
Okay. And so the total penalty that you found was $437,230. Is that right?
Correct.
All right. Thank you. I have no further questions.
I have questions. Can you please share the screen? Thank you. Mr. Witchery, you're not a lawyer, correct?
Correct.
You have any legal training at all?
No.
Okay, so when you give your interpretation, for instance, on the listing law, are you reviewing case law that says that the purpose of the listing law is to protect the public from the ills of illegal bid peddling and bid shopping that causes defective construction? Are you aware that that's what the cases say?
No, when I say interpretation, I've been doing this business for more than 20 years, and that's the translated from. I'm a professional engineer. I've been doing construction projects for almost all those 23 years, and that's how it gets translated to my engineer mind.
Okay, so it's possible that your engineering interpretation is not correct legal interpretation of what the subcontractor listing law either requires or authorizes. Is that fair?
It's fair.
I just want to document that again. I think you made this clear, but I want to raise it again. Bob Harari was running the project until June 17, 2017 when he left. Is that accurate?
That's correct, yes.
Okay. So you only knew anything about the project by what you heard in office discussions about it, and if he would informally talk to you about something, right? You had no official role on this project prior to that time.
No official
Correct.
role. Bob did report to me, but it was no official role in regarding to the day-to-day operations of the project.
Okay, so you don't know, or you can't dispute when Bob Harari and Asonio approved substitutions before your time. Is that correct and fair?
Yes.
Okay. And you didn't consider those emails that I've shown previously where Harari approves the substitution of EPD, European Paving Designs, and West Coast for the pavers and veneer work. You didn't include that in your analysis, is that correct?
I did not review those. I did not have access to them. They weren't.
You didn't have access to them? They're city documents.
I didn't look at them.
Okay. Sorry. So So just to be clear, they didn't enter into your analysis and your conclusions as you've just illuminated us at all about those approvals.
Correct.
Let's talk about other things that you considered. Mr. Firstman asked you a lot of stuff about claimed defects with West Coast and other work. Damaged pavers, you said that you were frustrated because there were long lead items and some showed up on the project damaged in transit. Is that right?
I don't know where they were damaged, but where the delivery transit, they were not installable.
Okay, so that's not a workmanship issue by any contractor on the project, as far as you're aware, right?
It is, because basically as you're transporting, you're looking for how to get shipping done. Perhaps they changed their shipping method and they went cheap route as opposed to what they should have done to protect the product. So it does rely upon the contractor to make sure that the materials that are provided to the site are in working order, and it does fall upon their responsibility.
Okay, and that's a fair concern. You know, you don't want to accept damaged work and damaged materials on your project, and the contract addresses the delivery of defective materials, doesn't it?
Yes.
Okay, so that's a contractual dispute. Would you agree?
It's a performance dispute because the contractor is supposed to provide usable materials that can be installed, and they didn't do so.
All right, and that's one of the many claims that are at issue in the ongoing litigation between our clients, correct?
There are.
Wait a minute, please. Let's not go into the litigation. Let's go into what's at issue here, which is the four different fines that are being asked to be assessed. Is that all right? Can we do that? Can we limit
Yeah,
ourselves?
I'm trying to tie this in.
We're not here till next Tuesday.
Yeah. Let me ask you this, Mr. Witcher, which is what I'm getting to. Did the damaged pavers factor into your decision to assess penalties for what you perceived were substitution violations?
I think the overall, what I'm going to call incompetence of the contractor to try to provide the material that they were contracted for did, yes.
Okay, so the damaged pavers factored into the penalties for a substitution violation in your mind? Yes?
Yes.
How about the broken cables? Did those factor into your determination to assess a penalty for unlawful substitution or listing violations?
So the broken cables, that was part of that. I think there were actually water lines that were broken, and that was a little bit of confusion in the earlier testimony. There were some broken water lines that flooded the area. I was aware of that. I'm not aware of broken cables.
But well, you said that West Coast hit cables was what the issue was. You don't recall that?
No.
So that didn't factor.
I'm sorry, I may have misheard through the system. I know there were pipelines. Sometimes they're called conduits or pipes, and I thought that's what it was referring to. I may have misheard the cable aspect of it. I apologize.
Okay. And did the broken water line factor into your decision to assess penalties?
I think once again, it reflects into the care that was given by the contractor performing the work at the site.
Mm-hmm. And the water intrusion issue, which was in January of 2017, which there's a lot of arguments in the litigation as to why work was going on and the roof wasn't totally covered up in January 2017, but that's for the litigation. Does the fact that there's water intrusion factor into your decision to recommend penalties in a quote listing law violation or a substitution violation?
Yes, because the waterproofing that was supposed to be done was supposed to be done by a firm that was not willing or capable or licensed to do that work, as listed so the listing violation, it identifies, looking down here on the exhibit, it's it's identified as Rinaldi. There's documents that show they couldn't do the waterproofing, they didn't want to do it, or it wasn't part of their scope. So who was supposed to do it if not them? And it caused a damage by that lack of attention. Okay,
but the claimed unlawful substitutions didn't cause the water intrusion, correct?
I don't know that, because basically I don't know who did the work.
Well, isn't it a matter of the building wasn't protected and the heavy rains of early 2017 penetrated the unprotected building and caused damage? That's what that letter in Exhibit 22 was about, wasn't it?
You have to pull it up again so we can look at that. But I think that had there been correct application of the product or the area, it may have contributed. I don't know. Pull that up.
Okay. So which claimed unlawful substitution resulted in that water intrusion?
Well, I know from the listing, it shows Rinaldi is doing the waterproofing. That's what
Yeah,
it's.
but what
And I-
Rinaldi is doing,
So I know we had leaks. So there's where my conclusion goes through is we have Rinaldi listed. They did not do the work. I don't know who did. So I would like to know that in that process in the listing, there's a listing violation. It's not identified.
you don't know who did it, but Rinaldi was doing waterproofing for pavers.
Rinaldi
stone
did,
veneer.
according to the documentation from Discovery, Rinaldi did no waterproofing.
Yeah, and that work hadn't been done yet, isn't that correct? The veneer and the vehicular pavers in the plaza hadn't been done until.
Arguing with him.
The point being is I don't know who did the waterproofing. Rinaldi wasn't part of it.
Can you move on, please?
Okay. Okay, so listing of West Coast on the bid and putting the wrong name down, or the substitution of the paver work to EPD in mid 2017, or the substitution of the stone veneer work to West Coast in April 2017, which of those three substitutions caused the water damage?
The waterproofing.
Do you know?
I do not know who did the waterproofing.
Okay. Mr. Firstman was asking a bunch of questions about payroll disputes and claims for proper payment by West Coast. Did those issues factor into your decision to recommend a penalty assessment in this case?
No.
Exhibit 28A, which was several FD Thomas provided warranties, those were provided at the end of the project, is that right?
Yes.
And the city received those warranties?
Yes.
City did not object to the warranties from FD Thomas, is that right?
No.
Okay. And there was no objection that, oh, you weren't listed in the original bid list and therefore I'm going to reject these warranties. There was no assertion of that by the city against FD Thomas or SEI for the provision of the warranties.
So at that point of time, recall, we've already had our damage. We have a contractor who appears to be functioning and be able to rectify the situation at FD Thomas. They were not shown in the original bid documents. It was going to be done by Rinaldi. There's where the trouble lies.
So it's in you. This listing issue has come up recently for you. This recently come to your attention, as I believe your testimony.
Yes.
Is that
last
accurate?
month, yes.
And in that time period, you're aware that the city has now moved to try and amend its litigation against Stronghold to add a whole bunch of claims based in part on purported listing errors. Are you aware of that?
I don't have the details of the litigation.
Is this hearing and your research into the number one, the listing of West Coast construction in the bid list, a litigation tactic intended to advance the city's litigation objectives in its lawsuit?
I just have to object. The council is mischaracterizing grossly the amendment in the litigation, which has to do with the unlicensed subcontractor.
Stay away from the litigation, both of you. We don't want to hear about that. That's not an issue here. Mr. Van Norman, okay?
Yes.
Thank you.
Just for the record, I will stay away from it. It is relevant to an abuse of discretion consideration. Should this?
He's already testified it didn't enter into his penalty, determining the amount of penalty. So you've got an answer already. Move on.
You indicated that when you started researching the West Coast listing in the bid list, that there were just too many small errors for your liking. Is that That's correct. That's what I wrote down on my notes.
Yes,
Okay. And when you say too many small errors, you mean writing West Coast Concrete when the legal name is Perry Construction, Perry Coast Construction, DBA West Coast Construction. That's one error.
so what I'm talking about is if there was an error where they had put WCC and put their correct license number, that I can totally understand that. I've been in this for 20 years and I've seen bids that come through that process. But the combination of having incorrect name, incorrect license number, that, and then the listings on the side, that's what leads me to this process. Because you can abbreviate something, but if you make an error on the other, and it's just too coincidental that the license number applies to a project, to a contractor that Mr. Perry disassociated himself to a month or so prior to the bid.
So your determination was that SEI intended to subcontract with Robert Perry's other entity, South Coast Construction, whose license number was on the bid?
My is that I do not know who or which one of those firms they were trying to contract with.
Okay, and so how is that a listing law violation?
Because basically, I don't know what kind of license they're trying to do the work under. Is it a B? Is it a C8? Is it a D54? I don't know what license they're trying to work under. So they put some erroneous information there. The sum total of that erroneous information is not helping me out to determine who was responsible for the work and are they capable of performing that work.
Okay, and again, just for clarity, you had no role in this project up until June 7th, 2017, after which the substitution of West Coast for express substitution approval for West Coast had already been given by Mr. Herreri and Asonio, correct?
Correct.
Okay, so you're raising all of these issues now years later during the middle of our ongoing disputes between the parties, correct?
Yes.
And West Coast was actually able to do its work despite the problems that it had, and it completed its work, correct?
The conference center stands. I don't know if it caused the delays or has contributed to delays, but the conference center stands.
Okay, and West Coast was part of that process the entire time, and the conference center is being used as it was constructed.
Except for COVID, yes.
Agreed?
Except for COVID, it's being used.
Fair enough, fair enough. What did the city, and I'm guessing you don't know the answer to this, but what, if anything, did the city do to review the list of subcontractors either submitted with the bid or the January 2016 version to make sure that your concerns that you had a concrete contractor doing concrete work?
Yeah, I don't know the review process for this bid. As Mr. McGahey pointed out, there was a protest that went on regarding different aspects of it. And I don't know, I wasn't party to the review or the process to review the actual bids on bid time.
Okay, and what happens generally during a bid protest?
Essentially,
I
what
don't know if
happens is essentially from a non-lawyer perspective is the firm who is protesting the bid brings certain items to the attention of the city and they protest on certain factors and request to have the bid removed from consideration. As I read through the documents and the protests and the responses, what I saw was the request centered around whether or not the contractor had fairly disclosed about lawsuits with other agencies, and particularly the city of Riverside, and particularly having to do with, has litigation ensued because of projects and the time period. That's what seemed to be the core of the protest. And ultimately in that situation, the lawyers for SEI and the city agreed that there was no actual contract between the city of Riverside and SEI at that time. Therefore, the litigation did not hit the letter of the requirement in the bid specifications.
Okay, so in this case, just in very simple terms, some other bidder protested SEI's bid as not complying with all of the bid documents in general.
Like they say, they
correct?
specifically point out to certain areas where they think it's defective. And the area that I recall being the primary point was the litigation aspect.
Okay, so the city actually had an opportunity, the bid was flagged for them back after the bids were opened, to look at the bids, make sure that SEI hadn't made any critical errors that were either unwaivable or that the city wasn't willing to live with, correct?
That's correct. And then the city actually had a response from SEI requesting them to respond on their behalf to the protest, which is typical. And in the response to that, SEI didn't clarify any of their clerical errors other than the ones that were accounted for within that protest.
Okay, but the city had the opportunity and didn't raise any issues with the subcontractor bid list.
I don't recall the nitty gritty. I just remember the major points was about the lawsuit issue.
Okay, and then 5 years down the road, we're arguing about the subcontractor bid list, right?
As Discovery produces documents and we see what's actually in there in the whole process, yes.
Yeah, after the project is done as well. And by the way, you agreed with Mr. McGahee's testimony that there was special contracting expertise required to do the bituminous bed setting for the pavers. You agree with that?
I think it had to be someone who had been experienced in installing pavers in that method. It was clearly laid out. I don't think it's proprietary by any stretch of the imagination. I think that's the word he used, was proprietary. I don't think it's proprietary. I just think that it's not something that is seen and somebody who's not doing that as their general work could do. If they were not a specialty paver, if they were not a paver contractor, they could not do it.
Okay, but you would agree that European Paving Designs was qualified to do the work and did the work in this case?
Yes.
Again, I want to go back to one more comment you made. That basically this hearing that we're going through today and the exchange of information about it is because of what you learned in the course of the discovery in the litigation. Correct?
Yes.
And also, I think this is the last question on with Mr. McGahee, that ultimately that scope of work was added to the contract after extended negotiations, including the negotiations over the value engineering, which I showed you in part in change order 2 that resulted in significant savings to the city. Do you agree that Jeffers Plaza was added to the contract after that extended negotiation and agreement on value engineering?
There's about 15 questions in there, and that's a very unfair question.
And it's not a yes or no answer.
Okay, let me try and break it down. Jeffers Plaza was authorized after extended value engineering discussions between SEI and the city. Is that correct?
The determination to move forward with Jeffers Plaza happened later on in the project. Jeffers Plaza was bid during construction. It was identified in the project plans and specifications, identified as a deductive alternative. So the prices and all the work for it were to be provided with the bid documents. There were concerns and value engineering that did occur. The value engineering that did occur helped move the project forward. And then subsequent to that, the change order for Jeffers Plaza work did occur. All
right, I want to show you what is part of our exhibits. Do this.
We have gone way over time here from
Okay.
what was allotted. How much more time do you need, and how can we wrap this up quickly? And I lay a lot of this to you, Honorum, because you didn't get information to us in a timely fashion.
All right, I'm getting close. What we have here, I'm showing you was part 2 of Exhibit B. It's a copy of Stronghold's proposal on November 2, 2015 for value engineering. Let me ask you, have you seen this document before?
I don't recall seeing it before. I no.
Because this was well before your time,
Yeah.
correct?
Yes.
Down here on this page, we have delete Jeffers Plaza was an $800,000 proposal from SEI to save money for the city, correct?
That's what it indicates.
Okay, and so it took from until this time, November 2015, until May of 2016, until the Jeffers Plaza scope being part of the contract was resolved. Would you agree with that generally?
I think determinations were made as the project went forward and when funding was going to be available, the decision to put Jeffers Plaza back in the project was made.
Okay, around May of 2016.
If that's what the documents show, yes. I don't have that document in front of me, but if that's what the documents show, yes.
Well, that's what I have for my notes from your earlier testimony, I believe. But you don't disagree with that in general?
In general, no.
Okay. All right, that's all I have right now. Thank you.
Clear your screen, please.
Is there any redirect, Mr. Firstman?
Not necessary.
Does the city have any other witnesses?
If it's relevant to the panel, we can submit to the panel the same evidence we submitted to the Superior Court on when SEI produced their documents in first part of 2019. And you've seen what Mr. McGahey had to say in his testimony at that time. But if when they gave us their documents is relevant to the panel, I'd like to submit that, but I don't think it is.
You can stipulate as to when the documents were first submitted and save us all a lot of trouble. It's a lot of time.
Mr. Van Ornum, you produced documents in March of 2019, correct?
I have no recollection as to when specific documents have been produced. Multiple tranches of documents have been produced over time. Sitting here right now, I don't know when documents. I know what you've said, but I don't know that I agree with that.
Okay, let's move on.
Yeah, I think I'd like to get to argument. And if
We still have a meeting after this, you know.
oh gosh, okay.
Okay, so if your case in chief is closed, both case in chief are closed, then we should open for public comment. And then after we do public comment, we'll have the ability for each side to make closing argument, reply.
Mr. Bruno wanted to comment earlier.
Yes, Mr. Bruno, if you're ready to comment, please go ahead.
Well, good evening. Thank you for the opportunity to speak. My name is Paul Bruno. I'm one of the owners of Monterey Peninsula Engineering. We're a local contracting company that's been in business here for approximately 40 years. We contracted with Stronghold on this particular project. We did not sign their onerous contract. Instead, we executed a 3-page agreement. As the work progressed, they repeatedly ignored the terms of that simple agreement. They were arrogant in their dealings with us. We'll never work with them again. Today, their attorney put forth a very weak excuse saying that, quote, bid day is a crazy day, end quote. He referred to the listing violation as a simple, quote, misreference, end quote. Mr. McGahey tried to support this by saying that the last hours of a bid is a, quote, absolutely mad rush, end quote, to get the numbers together. He implies that this is normal to use shortcuts such as listing just the first name, end quote, or even just the initials. Wow. Stronghold is basically admitting that they failed to follow the listing laws, implying that it's just too hard to follow the rules during the bid day rush. Getting the sub's name sort of close is not the standard. It's not how the law is enforced. The listing laws are very simple and clear. They're not hard to follow. In fact, you can do a lot of the work in advance. You make a preliminary list of the potential subs that you've been communicating with. You verify the potential sub's name and their license number. And when you make the final decision, you have the bid runner write their name and license number in the document. This is not rocket science. And don't be fooled. Stronghold is a very sophisticated general contractor. They are detail people, and I'm sure you know about it by now. They know how to write contracts, they write strong terms, and they enforce those terms against their subs. My experience with Stronghold is that they do not give in, they show no mercy. Don't let them get away with violating this very basic contracting requirement. And one final comment. On November 10th, after hearing about this, I contacted Tim Jackal, who's with Stronghold, and his comment was, quote, "That 400,000 ain't shit," end quote. Apparently, they think they're going to make so much money off this job that they laugh at $400,000 that you're trying to charge them. They know the rules, they're detail-oriented people, and for them to sit around here and tell us that filling out the forms properly is too hard is arrogant crap. Sorry to use those terms. But thank you very much for your time. I know you've had a long day. I hope this ends soon. Thank you.
Okay, thank you. Do we now open it up to discussion on the board, to the board?
Was there any additional public comment, Alicia?
At this time, Karen, I don't see anything else.
Okay.
We have their argument first.
Right. So given the late hour, does the board want to impose a time limit on the argument?
5 minutes is what was given originally for each of them. I think that's good.
Okay, I agree. Who wants to go first?
Well, I believe we said originally that Stronghold would go first.
Okay,
So if they could proceed with their argument, 5 minutes.
All right, well, just as my first comment, just reiterate our objection to the process procedure. This is a hearing on whether there was a listing law violation or several. And frankly, the position of Stronghold is pretty straightforward. And it's always difficult in these contested legal proceedings with different evidence coming in at different times and different points. But I think that the evidence has shown, and I'm just going to start with each one, related to West Coast and them being listed on the bid list initially with West Coast Concrete, which is how West Coast was referred to informally on the job throughout multiple job records, production reports, Exhibit 9, all of the exhibits 11 to 17, multiple emails with Mr. Harari before Mr. Witchery came on board. West Coast Concrete was the shorthand. Second, Stronghold received a bid from West Coast Construction. That's whose bid they used. That's how their pricing was for the subcontract for West Coast Construction. They signed the subcontract with West Coast Construction. They never changed them out. The rest of what Mr. Firstman wants you to believe is a bunch of red herrings and things that shouldn't be considered in this decision, whether or not there's a legally sufficient license. And I would offer that the license is totally appropriate. A B license may conduct work with multiple trades, and it's a totally adequate license. There's nothing wrong with that. So West Coast was the intended sub. It was not substituted. There's no violation. With the Rinaldi was listed to do 3 scopes of work, including the pavers, veneer, and the waterproofing. They refused to do that work. They didn't want to do it. They didn't do it. So as we've seen, there are emails approving the substitution before Mr. Witchery came on board, which he didn't consider at all in his recommendations because he didn't have access to them. Emails of March 23rd between all of the CM and Bob Harari approving the substitution of European Paving Designs to do the paver installation. They did it. It was approved. There's no listing law violation. It's a red herring that in the scope of trying to negotiate the change order to deductive changes for value engineering, that initially a purchase order or change order was granted to West Coast to order the materials, They didn't perform the work. The listing law applies to performing work and substituting subcontractors. EPD was approved and performed the work. There's no dispute, no violation. With regards to the stone veneer to West Coast Construction, again, that one was unequivocally approved in an email of April 10, 2017 by Bob Herreri. Nobody else did that work. West Coast did that work. There's no violation there. And frankly, that demonstrates that West Coast was approved and the team running the job before Mr. Witchery got there approved of West Coast in general performing that work with a B license doing paver work. They had no objection. There was no issue. West Coast was approved. So FD Thomas, as Mr. McGahey acknowledges in his affidavit, was a scope of work that was originally listed for Rinaldi. Rinaldi didn't want to do it. And in the course of doing the construction, SEI had to find somebody who would do it, and FD Thomas did it. And that original subcontract was $235,000, and that was a mistake by SEI. That was a mistake. The added part of the Jeffers Plaza, that's a change order. And as I offered to you earlier, Public Contract Code 4107 subdivision C provides that work added by change order, affected by change order, is not subject to the listing law. So that shouldn't factor in. Nonetheless, there was no objection by the city, despite all of the evidence that the city was directly involved with FD Thomas negotiating change orders for waterproofing, approving and aware of the progress that FD Thomas was making during the work, and that FD Thomas ultimately completed and warrantied the work. There was no objection. Only now, years after the fact, as part of the litigation strategy, is the city now trying to conjure up a listing law violation to support other claims in its litigation. So quite simply, there is no entitlement to any penalties, in part because a large part of what Mr. Witchery has testified to here today is that he's influenced by his own perception of licensing issues and poor work quality, things that have nothing to do with a listing law.
Mr. Van Ornum, just to let you know, you have 30 seconds remaining.
Thank you. So not only do I think that the substitutions were appropriate, the time has well run to assert any of these claims, and it would be abuse of discretion to levy any sort of penalty under this timing and under these circumstances. Thank you.
Okay, for the city of Monterey.
Thank you. This is Eric Firstman. I'm going to cover this very quickly. The listing of a concrete subcontractor and then contracting with a general building contractor is not only a violation of the listing law at the outset, but it's irresponsible. And it deprives everyone of the opportunity to protect the public. A general building contractor has no business taking a concrete subcontract. They're not qualified for it. What is the concrete work? It's carpentry, it's rebar, and it's concrete. Those are three related trades by definition. That requires a C8 license. And everyone was entitled to know that the subcontractor they planned to use didn't have a C8 license. They didn't have a D6 license. They had no concrete license whatsoever. And then they carry on for years as WCC Concrete. When you put the name concrete in your name, you need to have a concrete specialty license. That's the law. And if you have a name, you only use one name. You don't use different names for different projects or different contracts. That's the law. That's the contractor license law, is to protect exactly this. The pavers, the veneer, they listed Rinaldi. They never contracted with Rinaldi. They couldn't contract with Rinaldi. Rinaldi wasn't licensed to do that work. Who do they contract with? Perry. The same contractor that they just don't mention on their subcontracting list. Rinaldi didn't even bid the work. They excluded all this work from their bid. And a couple months later, who shows up with the work? Why? Perry. It's just bare, bald bid shopping the whole way. And what happens with bid shopping? People take work for prices that they just can't afford. What is it, the old saying, the job you take to keep the light on or to keep the lights on are the ones that turn the lights off? Well, look what happened. Look at the pavers that show up on site. Apparently they look like a jigsaw puzzle. Do we know exactly who caused the water intrusion? No. Who knows that? Why? The general contractor knows that. This was just bare bid shopping. Then with the issue of timing, you know, the listing law, it doesn't have a statute of limitations. If we were in court, this would be easy. They filed suit. They waive all the statute of limitations. They delay the production of documents. They mislead you in deposition on all of those grounds. Case closed. There's no statute issue. As the 6th District commented in the Thompson case, they're not aware of anything that disallows a public entity from using or relying on what they learn in discovery to enforce the listing law. And they say, you know, in fact, that would be bad policy. And you want to see the bad policy? What is the defense that we hear from this contractor over and over? You didn't catch us. You didn't catch us, did you? There's a sense of
30
entitlement.
seconds left, Mr. Firstman.
There's a sense of entitlement to break the law that you're seeing from this contractor, and it needs to be stopped. Thank you.
Okay, now we go on to deliberations of the board. Any questions or thoughts or comments?
I know we've all been here a long time, but I do have at least one question. Can someone, and I'm not sure who to direct this question to, can someone inform me about what approving a substitution means? Who is allowed to approve it? Is an email an approval? I don't know who to direct this question to.
I'll answer it. An email approval is totally fine. It was not contested. The subcontractor who was originally listed wanted to be out of that scope. The city can approve it unless it's disputed. If it's disputed, then it's the city's duty and obligation to set a hearing. There was no dispute, and the city approved the substitutions.
In the interest of fairness, I'd just ask if Mr. Firstman has any response.
Sure. I think when you look at any type of approval, you need to look at the information that it was based on. Now, the statute reads as it reads on the process that needs to be followed. And what was followed here was Rinaldi submitted a letter that implied that they realized they can't do it. The honest letter would have said, I never bid this in the first place. Why are you asking me now? The honest substitution request would have said, we have Perry under contract. We've had them under contract for a year. We'd like you to approve it now. Whenever you look at at consent. You need to look at whether it was, you need to look on what it was based on. And when you put false information in front of a decision maker, that decision is just, it's not valid.
So in other words, when Attorney Van Ornum basically said, or more than basically says, look, we've got an email that say the pavers were approved. We've got an email that the stone veneer was approved. This isn't a listing. This cannot be a listing violation. I think what I just heard you say, Attorney Firstman, was, no, we're not actually agreeing with that. We're not agreeing that those were approved because it's based on false information. Am I understanding you correctly?
Yes, exactly.
And let me respond to that. And let me respond strongly, because it really attacks the integrity of the SEI, and that's not fair, because what we've got is, no offense to Mr. Witry, but he wasn't there. We've got a reputable city person writing an email saying this is approved. And even in the first one, recognizing it's not a perfect request, but let's do it. Let's approve it, Dustin. It was approved. There was no evidence of any trickery. The letters say what they say and unequivocally were approved. And I really, really am frustrated by Mr. Firstman's accusations and implications to SEI. SEI bent over backwards to save the city's project and built it, and is owed a ton of money. There's no evidence to support any kind of claim of fraud, and this is just inappropriate, and it shouldn't be here.
The requests are in the record. The panel can read them and compare them to the facts.
Okay, let's take it back to the board for deliberation.
Stephen, any thoughts or comments?
Yeah. I spent 17 plus years as an assistant city attorney, and one of my duties was public works contracts. So I've been listening to both sides, and both, despite my questions, both sides have presented their case quite capably. Should be complimented on that. As far as the Perry subcontract, there's no question there was a violation of the listing. Okay, and three different things. It was either sloppy, probably more than anything else, but nevertheless, it was a violation. And as far as the paver change order and the stone veneer, that certainly smacks of bid shopping. And remember, we're here with preponderance of the evidence, and which means more likely than not, unquestionably, in my mind, there was the Perry subcontract, and the listing of West Coast Concrete was a violation. A bid shopping, yes. And the waterproofing, nobody was in charge. The general contractor should have been in charge. As far as I'm concerned, the violations have been proved. As far as the amount of the penalty that should be imposed, I think we as a board can talk about that. That's what I have. Thank you, Chair.
Okay. Kent, do you have any thoughts or comments to share or questions?
Well, this is obviously a really complicated case for me, as not an engineer, neither a lawyer, etc. I don't feel that the preponderance of the evidence, Stephen, with regards to the issue of pavers and stone veneer, well, those two things. I feel like there was an approval for those things, and I hear the reasons behind that about whether Attorney Firstman, I heard what you said, right, about not taking that on face value. I don't feel like I have enough evidence to actually say that those are violations. But for me, I do feel like there's enough evidence for the other violations that are in the Director of Public Works memo to us, letter.
Okay, we do have an option if you wish to consider it longer. Another meeting on December 7th, which will be a little shorter than this one. We could continue to that, or is someone ready to make a motion?
I would make a motion in light of what's been said that we assess a 10% penalty of $291,000 for the Perry subcontract, not assess anything for the paver and stones having been approved by a change order, and then $50,000 for the waterproofing for a total of $341,000.
Okay, and I agree with that. I would second that motion. I like that, agree with that, and would uphold that. Any other thoughts or comments? Are we ready to vote?
Yeah, I am.
Okay.
Just if I may, could you include in your motion that we come back at the December 7th meeting and you can approve the language of an actual order assessing that?
So make
Okay.
it as amendment to my motion.
Okay, good. Shall we,
ready?
yeah,
We're ready
Shall
for a
we
roll
vote?
call?
yes.
Okay. Board Member Glenzer,
I'm in favor of the motion.
Chair Hawkins,
Yes.
and Board Member Milich.
Yes.
Okay. The motion has passed 3-0.
Good. So we're actually done, I think. Anything else I'm supposed to cover here?
No, I think we can adjourn.
Okay.
So
well,
I'll
thank-
return on the 7th with the findings and approval of the final order as directed by the motion.
I just want to say that the 2 hours set for this meeting remind me of an attorney, just one more question.
Do we know of the time for that meeting in December? Is that set yet?
Yes, it is.
2 o'clock.
Thank
I
you.
believe. Yes.
And we would like a copy of the record of this proceeding. How do we do that, given it's Zoom?
It is being recorded, and so once the recording is finished, we can get you a recording if you do need that.
Yes, we will.
Okay, no problem.
Are we done? Thank you for your patience. We've covered a lot of information today, and it's a difficult subject. So thank you very much.
Okay.
One question I have for Alicia.
Yeah.
Do you want the exhibits back? Do we have 3?
Oh, I'll contact you and come get those from you.
Okay, thank you.
Okay. Thank you,
Okay.
everyone, for showing up.
Yes, thank you.
We're adjourned. Okay, we're
Yeah.
adjourned.